welcome to the July 16 meeting of the Friday Reservation Water Management Board. Start with that open prayer.
That's great. Dear Lord, we just want to take a moment today and acknowledge you and thank you for the day that you have blessed us with and for the people you've blessed us to share it with. We ask for your wisdom and guidance as we go through our meeting today, that we consider carefully the decisions we make and do so with a servant's heart toward the people we serve. And we do ask for special prayers today for those who are hurting and healing, and just ask that you be with them. In your name we pray. Amen.
Okay, as always, meeting minutes can be found at www.FRWMB.gov for those who are interested in previous meeting minutes. Tennis,
Clayton Matt,
here.
Roger Noble,
Here.
George McLeod,
Here.
Ken Peck,
Here.
Georgia Sneeze, here.
And we are still without a federal non-voting rep, but we do have a quorum and we'll move on. Thank you. Looking at the agenda so far, at least any potential conflicts of interest, Georgia?
No.
Ken? No. Roger? No. George?
No.
None for myself, thank you. All right, on to adopting the agenda, I know I had some comments and suggestions, I think, for the agenda, so Roger, did you have something?
Yeah, I guess, so under 6.1, discussion of PTO. I guess I don't know if we make modifications today, if we need to insert public comment and board action underneath that. Or if that will be covered under the 6.3. We got further 24 on today's agenda.
So discussion of PTO, I know there was a suggestion that we may want to take action on that. So from Ethan's standpoint, from Haley's standpoint, can we have that now?
My suggestion would be to have the full discussion about it today, so that we can at least get some draft language if needed, within the policies, and then have it on for board approval at the next meeting.
Right.
And then 6.2, I guess I'm not ready for that one, so I want to remove 6.2 from today's agenda.
Okay. So given that, what was the 6.3? Is that something associated with? Can you remind us what 6.3 is?
Mr. Chairman, board members, you had put a 15-day public comment item out relating specifically to portion 3.15 of the personnel policies, and that is the section that used to contain a physical fitness leave that the board struck from the leave policy and put out to notice. And so if you wanted to adopt that today,
All right, because we'll keep that, all right. So we'll keep discussion on PTO. Any objections to removing 6.2? Okay, we'll remove 6.2. Any other thoughts on the agenda?
Just when you get it wrapped up, don't forget to go back and hit 1.5. I think we skipped over the meeting minutes.
Okay. Yeah.
I'd make a motion then to amend the agenda to remove 6.2 and
That's the only change.
yeah,
In the docket.
and about
Okay, motion by Roger.
I'll second. Go ahead.
Second by Ken. In favor, say aye.
Aye.
Aye. We have that. So 1.5, meeting minutes from 6/24/25, please.
Mr. Chair, I move that we adopt the 6/24 meeting minutes.
Motion by Georgia,
I'm second.
second by George, all in favor, say aye.
Aye.
Um, Any public comment or items not on the agenda or non-action agenda items, so we actually have some public today, so if you do have a comment, please come up, state your name, and give us your comments.
Mr. Chairman, I do have, I did speak with Ms. Normando, and she's got a little bit of a tight timeline, and she wanted to offer just a real general comment about, it is an item that's on the agenda, but not, her comment's not specific to, changes or anything she'd like to see, just a general thought about an item.
Yeah.
I was hoping you might, as a board, hear her, since she's got some other commitments today.
Let's do it, I mean, now for the public comment period, you have one.
Yeah, yes, sir. That's what I was suggesting. Assuming you'd like to still speak, Ms. Amanda.
Welcome.
Come on up to the
Come on
podium
up.
here and
Give us your
grab
name.
you up there.
We won't, we promise we won't bite, we're just glad to have you. Glad to have you. Give us your name and, go ahead and give us your comment.
Renee Normando, my neighbor Wayne Cross is here too. We live over in Camp Prairie. And, we came today to ask if you guys could, go over the water rights abandonment issue that we have. There's another guy on the prairie that wants to irrigate. And, we just, the water table is going down. We're worried about not only our irrigation, but my water well, water from the cattle. We just want to file some paperwork for the water rights abandonment because it hasn't been used as far as anybody knows for way, way over 10 years. So, just if you guys could go over that as soon as possible, so we can file some paperwork if you think that would be okay. We would sure appreciate it. I don't know what else to say.
Normally, we just take your comments, but I just a question, so the abandonment issue you have is on your own?
No, it's the guy that's putting the new irrigation
Okay.
system in.
Um,
Sorry, I didn't clarify things.
no, it's okay. And your point to the board is to address the water rights abandonment policy, is that not in the policy now?
Mr. Chairman, board members, we have before you today some water policy and procedures that would make clarifications about a declaration of abandonment procedure. And you also have a form that would be needed for somebody to file. That is a draft form that's available today for you to look at.
Any other comments?
No, I just really don't want him without irrigation system because I don't know what it's gonna do to our water table. So that was all I had to come and say.
Thank you very much.
Thank you.
Thanks, Ethan. Heather,
Yeah, my name is Wayne Cross. I've lived on Path for 71 years. Irrigator. I think Renee covered most of what we want. I'd like to see if maybe you guys could expedite an abandonment. And so anyway, really don't have a lot to add except that I have 3 shallow wells and 1 cased well. And like she said, the water table just seems to be getting weaker and weaker in the drought, whatever, every year. So, and pretty sure that this new well that's being put in, it seems like it's kind of outlawed in. There's been no new well filed, although the water right was filed in 1954, but like I say, I'm 71 years old and I've never seen any irrigation on that piece of ground with that well. Gone by there, it's right next to the highway. So. Like maybe proceed, he's doing a lot of infrastructure work right now. It seems like he's at a mad scramble to get the thing going, you know, and I'm assuming without any of the proper stuff, and so. It's like it's probably.
So, what you're bringing up is the same issue as the Randall.
Correct.
Same individual.
Yes,
And so from an irrigation development standpoint, what you're talking about is a well.
yes, it's a backward dug well, a shallow well, culvert through. And it was dug, the hole was dug last fall, I don't know exactly what day, but last fall, saw it go in. And then early this spring, the culvert was thrown in, covered up. Just yesterday, they've been pouring concrete, digging the main line, the wheel lines have already been set up. So. It's happening fast, I guess.
Thank you.
Gotcha. Thank you.
More discussion on this comments at all? I guess. Ethan is, given that, I know that the question was raised is abandonment. But given the nature of the comment also, is it appropriate for us, for you to inspect this bed well? For any potential water right issue?
Sir, sure, Mr. Chairman, board members. So, the folks that were before you here a second ago originally interacted with our office, with the desire to file a complaint. And, you know, on the cursory look, there was in fact a water right, for the use that they had not seen before. And that, pushed, our office, generally to conclude that if they were gonna file something and be filing an issue of abandonment. There's a petition process in the ordinance that sets forth the way to file to petition to abandon a water right. And we do not have any policies set up for that, and we do not have any draft, any forms for filing that kind of an action with our office. And so we created what we thought was the, you know, a couple of needed clarifications about the ordinance in terms of what the abandonment is, how it's defined. Also,
Yeah, hold on.
I'm sorry.
Say, Seth, excuse me, I apologize, but you guys are free to talk, but I need to get if you guys want to step out for a minute while you're talking, that'll help us. Appreciate it. Thank you. So. Sounds like a pre-1973 water. Well, that was. I think kind of leading for what I'm wondering is. If there was. Some record of some water record. But they're just now. Digging this. Well / pit. What was the original diversion?
Well, so they would have needed to file a replacement well with our office.
The original was the well?
That's my understanding. Of course, I wasn't around.
No, but
But
the record showed that
Yeah.
the water right associated with this was a well.
apparently shallow. But
And it's not used for,
I've not gone out there because I mean, I would need somebody to file something for me to go out and perform some sort of an investigation on that front. I guess it's sort of like if it was a complaint. Now, the water right owners would have a full 120 days, I think it is, to file a notice of completion for replacement well. Just, if that was done legitimately, they would potentially not necessarily be in violation of that requirement from the ordinance at this time, but, this other issue, was, different because multiple, people from that area had said that they had never seen the use there, for, a very long time, and so they wanted to have some way to be heard about this new use that they had never seen coming online. My read of the ordinance is that there is one component of the ordinance that includes this abandonment. And that if we were gonna proceed with that, I would want you as board to approve the form and then take a look at the clarifications that you'll ultimately get to see when we move to that item on the agenda. I hope I'm doing all right job explaining that.
Yeah,
Okay.
my question still goes to whether or not, given the comments, not just comments here, but apparently discussion we had with those individuals about this potential conflict. Would it be appropriate for them to go ahead and file a complaint so you could at least do an investigation, an initial investigation? Part of, I'm also kind of in the back of my head thinking, now thinking out loud about potential issue with what they're doing. If there is an issue, this person spending a whole lot of time and money to put this back to use. If it's inappropriate for them, maybe they should know sooner than later. It's part of the thing. Like, I'm not sure how else to approach this or what else is in the ordinance that would, at this point, allow you to get out there, but that's my question. How else do we respond to this?
So Ethan, my first question is, what basin is this?
This is, up in the Hot Springs area.
So is it 76 L then,
I think that's out, yeah.
or is that over there?
No, it's out.
It's out.
Yeah, okay, so then. Because the water court's still going through their adjudication of those basins. Is it our purview then to do something, or is
That was
this
my question.
under the water court?
Yeah.
Yeah,
It's a 373 right, so the water court theoretically would have jurisdiction. I don't know, I'm not saying yes or no, that we have jurisdiction.
yeah, I guess my question is, do they need to go file an objection with the water court? With the objection period just got extended too, so they can do that.
I thought it was August.
It was August 22, but it got moved to November. So it just came out with the room.
Some of this is me looking to you to tell me what to do. And, so you as a body need to kind of give me some direction. That's why, I felt like it was appropriate to try to get this in front of you and give you an opportunity to direct me. Haley, at least, you know, is familiar enough. It got queued up, so she's been, trying to, you know, get as informed as possible to help to discuss this item today, I think.
Yeah, well, I appreciate it. I mean, I, on the objection of what we've done, I just want to make sure that if there isn't more we can do, what should we do? Should we do that? And then there's this question of whether or not, aside from that, whether or not, their more proper course is to go file an objection maybe with the law court. Haley, have you looked at it enough to be able to advise us on a proper course of action for the board?
Yeah, I mean, as far as looking over these procedures in the petition that's in front of you today, I don't see any issues with that because it's something that you will need to review anyway. There is a procedure within the ordinance that allows for the office of the engineer to determine abandonment on its own with evidence presented to it. So that there is that process that is available. I don't know enough about these water rights, that are at issue to know what the jurisdiction would be on it, so I can't advise the board in this open meeting on that. Nor do I want to.
Yeah.
That would be something that, I'm happy to discuss after this meeting. But as far as the policies and the petition that's in front of you today, there is no issue with reviewing that.
Petition meeting, the comments that we just made.
No, there is a form in front of you today, that's a petition to declare abandonment. That is different than a complaint, so I don't wanna confuse anybody.
Well, let me make sure I'm clear. So you're talking about a form that's been filled out, or a form you have to approve.
Today in your packet, you have two forms that would be available for your approval. One of them is a form that these folks can file if they so choose
So
with our office, that is petition to.
the form we haven't approved yet.
It's true,
Okay.
yep. But they are drafted in your packet, and they trail after the water policies and procedures. So first, there's a policy and procedure section in your agenda where, and the abandonment's not the only thing in that, just so you, I mean, I don't want to try to overwhelm you, but
Yeah.
it's in the order of occurrences through the WPMP on items that we would like to have you consider to clarify the ordinance. But then there's also a follow-up where there are two forms. One is a modification of an existing form that moves that 6-month deadline extension to a 1-year deadline extension, which is something that we talked about before, and I will do a better job queuing that up for your discussion and consideration when we get to that item. And then the other one, the other form, which I believe is fundamentally needed. I do believe I need an approved form from you to receive a petition to abandon the water. And it doesn't mean that we're gonna, that moves forward with investigation and hearing type actions, does not define an outcome or decision. And I, you know, probably don't want to talk too much about the specific details of this. We're really looking at the process.
Yeah, no, I'm following that.
Okay.
My questions really go to setting aside the abandonment question that's been raised to.
So
There is nothing else that gives you authority to go out and at least investigate because of, it's been brought to our attention already.
Mr. Chairman, I would not, from what I took a look at, I would say no. And I would not proceed because there is a piece of paper that's out there that covers that particular area. And therefore, you know, if I was just on the face value of, let's say, a complaint that was filed with this office, I would see that, you know, there is in fact a water right out there. And none of the discussion has been about, you know, a use of that different than what, you know,
What do you mean by a piece of paper?
there's a paper water right that's out there that describes water use in that area. I'm sorry for the bad terminology.
No, that's fine. Well, maybe too much more. So Ethan, is there something, if we don't, I mean, we certainly don't want to try to consider the details of this right now. I'm just trying to clarify in terms of next steps. So, but if the question raised about the water quote is a valid question, do we provide these individuals with that information so that they can decide how do we handle that? Or do we?
Yeah, I mean, the office can most certainly instruct those individuals that this potential recourse within the water court, through an objection.
In addition to whatever we're doing here.
Yeah,
Yeah.
they could do that their own
Yeah.
tomorrow,
Yeah, they may not know that that's,
but they don't.
I'm just,
Yeah, I think that's the key. They don't know that's enough.
yeah, so. Yeah, so if you were advising of that, I'd be comfortable with that, but it's certainly not directing me to do it. You know, it just sounds like it makes sense to me.
But it'd be good for them to be at least aware of that.
Yeah.
But they, then it's their decision whether they want to pursue it or not.
That may be an option.
Sure.
Any other, so we're still in the public comment portion, but anybody online, you know, there's public here, anybody online?
The public online.
No public online, all right. Moving on, closing the public comment. Water policy and procedure discussions, all right. Council and water.
Oh, management.
3.1.
Today, I'm gonna need you to do a lot of fancy driving for this one. I'm actually just gonna sit here, Mr. Chairman, sorry, instead of getting up the podium, so I can use my computer if I need to.
You're good, thank you.
Thank you.
Also, just to be clear, you know, Ethan asked for that. If I say we're good, that's fine with me. If anybody has an objection to that, I'll speak up. I'm willing to do whatever the board wants. Thanks, Ethan.
Mr. Chairman, I'm just gonna start kind of tackling these, as we go through the line. Of course, you or any board member that would like to, interject anything, you'll need to do so. The arrangement for these water policies and procedures, does take the lot of whatever gets moved forward here today, combines them all into one group and puts and would, if the board decided to take action, would put those draft water policies and procedures out for a 15-day public notice. So the way that things could work here today is that when you do ultimately make a motion, you will decide, I think, suggest that you would go down the line of each one of these groups of WPMPs and decide whether or not you wanted to move them along, or if you wanted to hold something back. And then as we go through each one of them and the wording, I believe that this would be an excellent time for this board to do specific line item changes that you might like to see, or additions as we move through that. It's been a while since we've worked through some of the WPMPs, so I just thought I'd offer that as a reminder.
Okay, so what we're looking at on the screen is what we have to work with. That's not in the packet. Need to be, I'm just asking to make sure I'm not missing something.
Yeah, so the document itself is 46 pages.
Okay, it's on.
So, this will Chairman,
Yes,
question?
yes.
I know Seth is here. I didn't know Seth was here to listen and if you had any comments.
I talked to Seth earlier. I think Seth is here to support some discussion that's gonna happen. Yeah, discussion. So he's here to make you nervous.
Yeah, behind my back. He likes to bribe with the chair. And all.
Absolutely. Thank you. And Ethan.
All right, Mr. Chairman, the first item here would be WPMP 10-102 sub 9. We have encountered a new type of ownership that was new to us in our office, and we needed to have some clarifications. This section of the WPMP does make clarifications on, you know, how our office would handle application signature requirements and water right ownership listing in the issuance. Before this, it was only for contract for deed, but we have run in additionally to a new arrangement called the deed of trust. And in the deed of trust, there's a grantor, and that grantor is our determination from looking at both the specific one that came into the office and generally looking over other deed of trust arrangements and discussing with council that for those, we really need the grantor to sign the water right application with original signatures. And that the other folks that are part of the agreement do not need to sign and would also not end up on the issuance of the water right. And so this is a little bit of an administrative item, but it does in fact affect a private property right and how we would manage an application received. So that's why we wanted to add this into our WPDs.
So what the deed of trust is exactly what?
Yeah, I mean, it's essentially, so for example, you'll have an arrangement where somebody buys a parcel. But they have to buy it through a loan from like a title company. That title company will hold the like legal title to the parcel. But then that person who purchased the parcel will hold equitable title to the parcel. So they can use what's on the parcel. And they can use the home if there's one on there, use the water, use the mineral rights, use the land. But for that purpose, the title or the bank or title company or the bank will hold the legal title until the loan is paid off, essentially.
So given what we just said, who's the grantor?
The grantor is the individual who owns the parcel, so like who purchased the parcel. So if it's like Joe Smith, they would be the grantor. The trustee is the title company or the bank.
So the original, so the signatures are made by.
The grantor for us, if you're gonna, if a grantor who's part of this deed of trust is gonna get a water right on this parcel, then, because it took us a little time to figure this out, I didn't know this just right off the hip, okay? But that would be who we need to have give us the original signature, and that we don't need the other two parties to this to sign that. You know, we would issue that water right the same accordingly. And then we have a little bit of language in here about like if the property is foreclosed before we issue the water right, the new owners would provide the OE with an updated deed and file an application owner update form, not to be confused with any water right ownership update. This is an application. It's a pending application update form. We do have that form. We do use those surprisingly often. And it's for something where there's not been an issuance yet. And this clarification will help staff and myself remember this this decision point if you agree and move this one.
Excuse my confusion here. So you have an individual who's buying property
They purchased it
and.
like through this deed of trust, so the bank
the deed of
or the
trust,
title
so
company.
that company technically owns it. So.
Legal right, yeah.
So the grantor is granting what? To who?
Will eventually grant the parcel to some grantee, once all of the consideration has been taken care of between the grantor and the trustee. It's a very complicated
So
situation,
once, and if that does go through as opposed to not going through,
right?
then does the names change again?
From the one that I saw, they would not. The grantor, it's the grantor grants this should they not pay off the entire debt. So
If all conditions are met, then the parcel would, yeah, go to the grantee. So at that point, an ownership update would need to
Yeah,
occur,
okay.
yes,
Okay.
so that the grantee is then the current owner of the parcel.
That was what I wasn't checking. All right.
All right,
Any other questions on that? So what we're trying to do is go through these and sort of thumbs up or thumbs down on what we've done here. You know, it's thumbs up, we just move on, thumbs down, we either don't do it or we modify the language. Ken, Georgia, Roger, George, you think, so,
All good.
do we have a thumbs up? Okay, thumbs up. It's our fancy way of saying consensus of this. Will that work? Okay. So how did you run across that one?
somebody filed. Filed something we haven't seen yet.
So Ethan, have you ever had somebody file, or I don't even know how this would work, but where they don't want the water right to go with the land? Like they're selling land, but they want to sever the water right?
That is called a sever. And that typically falls under the umbrella of an ownership update.
Okay,
And we haven't seen a whole lot of severing, and in Montana, severing a water right, well, you have to do something else with it, and doing something else with a water right would typically mean you have to change it in Montana. And so it is, that's a project. But it does happen.
it does. Huh, I was just curious.
You can sever it, and hold it in abeyance.
Yes.
Is that very common?
No, not many people know about that, so it's hard to do that.
Gotcha.
It's also really not, something that like a realtor would ever suggest anyway, because having the water right adds value to the property.
Right.
So unless there's some sort of, need to do that, it's not typically something that's recommended, yeah.
Gotcha.
And
That's just
I
curious.
would theoretically put it in the category of somebody wanting to lease or sell it. Which is. Typically legal.
That's why a lot of the old ranch water rights have like 100 people's names on, because the water right stayed with the property, and the property started being owned by a whole bunch of different people, and then as each parcel division and new owner comes on, they get added to that same original water right that might have been owned by one family at some point.
Wow.
Um,
You can get complex in a hurry, can't it?
Oh. Yeah, a lot of them. Around Kalispell, with some of that old farm ground, big ground became subdivisions.
Hmm.
Then you've got a ton of owners on this water right, they will never use it, never be able to get access to the point of working. It's a mess.
Wow.
I don't know, they need to clean it up.
Yeah, well, or you have over appropriation issues as well. So like if you start adding more owners onto this original historic water right, that was maybe for one big farm at one point. When you start adding all these little owners onto it, you'll have an over appropriation of that water right, meaning that all these people are using in excess of what it was historically granted for, so.
I was planning a trivia night. I was coming up with questions. And one of the things I stumbled across is that in the state of Montana, the city of Kalispell is the fastest growing city in the state.
Yeah.
So I could see where
Yeah.
those kind of issues bubble up, right?
So in that kind of case, it is good to sever that water right and lift it off the property, because that water right will never be used by all those people, they're gonna be hooked to city water,
Yeah,
so.
but we have a form and a process for that. Okay. That's what I thought.
Sorry, we're trying to make something, a small change, that'll make this easier to read for you.
That's why I brought my laptop today. I can read it right in front of me.
So I'm gonna jump in here real quick. Apologies, but I need to step out for a few minutes. And with Aaron, I will come right back. Please continue, if you get to something that you want me to participate in, just skip it till the back of this. Something I do need to. Okay, done. So, okay? Yes. Okay. Thank you.
All right, we have a section here about connections to water rights with a priority date. Yeah, all right, so this is in the database. This discusses, sorry, I should have done a little better overview here. But this discusses possible corrections to water rights. And there are two, originally, these were combined because of some concerns from the Montana DNRC about some statements of claim. I kind of rewrote and reorganized this a little bit and separated the statements of claim, which would be water rights with the priority date of July 1st, prior to July 1st, 1973, which is under 3 now, versus item 2, which would be everything else, things that were issued after 1973 and are not statements of claim that would normally be managed by the Montana DNRC. And so we have a moment here where we really need to get the board's input on how much our office is able to get in and make corrections to water rights. And there's some things that we all agree should be able to be managed, like fixing geocode numbers that are obviously a typographical error, fixing names that are spelled wrong, fixing other aspects of the water right where maybe the issuance is a typo compared to what was filed for and what was approved in the filing information scans. And we've had some back and forth about, well, how much should our office be able to manage this issue? And there's two things that I think you should consider as we talk and we move things forward. The first item is that a lot of the water right records have errors and omissions, and a lot of the original filing forms did not ask for information that would be of significance today. So if you find an older 602, they might have been using a deep well and a shallow well, but it didn't ask for that kind of information at all. It didn't even ask for what the lawn and garden size was. And so the second thing that you need to be aware of is that certain aspects of the water right, when you change them, would normally trigger a change authorization. And so what we're trying to do here is kind of find a good spot to balance out, this bifurcated, track. What can we change without having to go through a big change authorization? And so for us, we think that, generally, if we can identify that the item was an omission, that the item was an error, that the item that would be changed is unlikely to, make a big effect to other users, we think we should be able to create a memo to the file and make that correction without having the water right owner go through a full change authorization process. If, in contrast, somebody needs to move a head gate or they're looking to go to a different source, we think that those are kind of triggering events that are likely to push us out of correction consideration and into, you just need to file for a change authorization, which would then become a public noticed an organized, conducted look at, dealing with things. Now, this is your opportunity to put some sideboards on this office or, let us move forward. I think a lot of the things that we're wanting to correct on water rights really are just, you're not, this is post 73 water rights, and I'll just remind you for this particular discussion. I really don't think that, I think that there are things that can really affect a water right owner in a bad way because their water right doesn't reflect a pond that was clearly drawn on the file for document didn't occur in the issuance, smaller. And it's been there, and we could see it on the ground since the origin of that. Things like that, we think we should probably be able to just handle that through a correction. This is your time to, kind of say, no, we don't think that. We do also think if we're gonna do that, with add a memo to the file that, signify that we did such a correction. And that correction came out of this office, not some other office. In contrast, when we get into pre-73 statements of claim, we do not think that we should be tinkering around with those beyond these smaller items. Misspelled names, misnumbered geocodes that do not significantly move or shift the ownerships, just if it's clearly an error. Those are the vast majority of things. We also have the opportunity to assign title status reports to water rights in this office, which is the track number that the BIA uses for their parcel tracking, which is different than a geocode. We think we should be able to modify those on a statement of claim, which is really just a locational situation using a map layer that nobody else in the state really uses. And we think that that's it. I did have a very detailed discussion with Ayla Hoyt, the compact implementation program manager. I noticed Blair's on here also today. If he wants to chime in, he's welcome to. But she helped to kind of run this through DNRC and agreed that some of the things that we need to correct would be a benefit here to have those corrections. She also helped set some sideboards on things such as if you get married and you change your name, that's not a correction. That's an ownership update. That needs to go through the formal ownership update process. And so just to give you a more tangible idea of where we're going to be drawing the line on some of these items, that's a clarification that we would not proceed with doing under the idea of a correction. Additionally, I have plans that we're gonna get DNRC's updated guidance that goes out to staff. They're working on that right now on what name and address corrections should occur on a regular basis when the water rights staff is looking at claims off of the reservation. And we will do our best to provide consistent application of that here the same way that DNRC does off the reservation. And that I think we're all in pretty good lockstep. That's in alignment with what the state is doing. And we're going to try to keep that dialogue moving forward so that we don't have any ideas that maybe this is usurping the water quality authority in any way. And instead, this is just a corrected reference. Haley, you were jumping on anything?
No, I thought that was a good rundown of that. So, I mean, if there's any questions.
So I guess what to recap a little bit, what you're telling us is this WPMP 11-108. All of what we're looking at there is new language,
Yes, sir.
right? I guess I have two questions. One is, even making minor changes to a 373 water right, why don't we let the water court do that? Why are we, especially since it's in the adjudication stage right now? That's what you do right now, is you correct those issue remarks through an objection. And that's how they get it. You could file an amendment up until recently, but now you can still do the objection thing. So why are we fooling with those when they're still being looked at by the water court?
This from DNRC, correcting owner names and addresses is not within water court jurisdiction. And off of the Flathead Reservation, DNRC has jurisdiction to correct owner names and addresses, and they're the only ones doing it. That's the main reason. So, yeah, that's what we're just trying to keep consistent with what is occurring off the reservation in terms of claims. And my understanding is that there's not another avenue for some of those, again, not to be confused with last names change when you get married, but just actual corrections. Like names and addresses.
And the DNRC isn't on board with all of that procedure?
I mean, I'm not gonna put words in their mouth, and they do have a 15-day opportunity to provide formal comment. So yeah, I think that the last updates, we tried to accommodate some things. I think this last communication I had got us a little closer. If they have some specific proposed modifications on volumes.
Any other board members have questions?
This last communication was just today, right? Just wanted to complete. Or,
Yesterday?
yes,
Yep. Yes.
I read.
Okay. There was a follow-up after the communication where Kayla had reached out to the board to express the concerns, and I invited her to have a meeting on the side and talk. She did that, and you did that, and I do have a correspondence from her, because she went and talked to Nate and Golden and others at DNRC. Todd, I am coming blank on Todd's last name, but he's the adjudication bureau chief. Yeah,
You take that?
Well, I'm still a little concerned with Ayla's, what she was talking to you about, because she seemed really adamant that it should be the water court. And then, never did see it the rest of it, so we had further communication.
all right, I will,
And it just flooded.
I will forward this on to you also.
Yeah, I'd like to see that too. I have the same concerns. So,
All righty, Mr. Vice Chair, can I please?
are we okay? All right, this would give us one thumbs up for now. Okay, and then you'll get us that information. We can put it up. All right, we're on to WPMP 21-106. We just gave that one consensus. Cool.
On the quota.
All right, thanks for that.
All right, Chairman, Vice Chairman, board members, this 106 and 107 are things that we think we need to move forward with state-based registrations. As you know, we have requested our first official batch of state-based registrations that are in the office. We're working through it live to make sure that we have everything that we need, and we have written some policy that we think will help us determine how to manage the filings for these. There's this discussion of the certain unreported existing uses. Sorry, trying to catch up myself.
The question is the language that's highlighted.
Yeah. See, check something there. So. All right, sorry to be there. So what we've got here is we really are just defining that all three of the three types of registrations that could be registered under the ordinance, which would include 602s, both ones that were filed before the effective date, and then ones that were filed during the 180-day period. 605s that were 602s were general groundwater water rights that are permanent sections. 605s are stock water of the same type, and then there's this group called 222Fs, which are pre-1973 exempt uses for which people were not required to file a water right. Those were limited to like domestic uses and stock direct from source. And that here we want to cumulatively call all of those state-based registrations.
So the sentence, cumulative, these uses are defined by state-based registrations, maybe just a period right there.
I think that is an improvement, and it's part of why that's getting home from. So I think and there is as to the NRC. Yeah. And you can delete the last sentence. It looks like it was editing error here.
And then Haley's, your comment is associated with number 2.
Yeah, I mean, so I'll let Ethan explain that, and then, I mean, if we want to have that conversation, we can, so just let him explain it first.
All right, item number 2, determination of duplicative water court filing. There is in the definition of the, again, the 222F, which is actually an abbreviated reference to the Montana code annotated that allow for exempt uses. But it does make it clear in the ordinance that to be eligible to register those uses, they could not have also been filed for in the general stream adjudication. And so to us, that means if you filed the same in-stream stock use direct from source with the water court, and then you also filed it as a registration. That it would not be eligible to have been filed for as a registration because it had already been filed for with the Montana Water Court. I know that that's being overly specific, but, that puts us in a bit of a weird spot because there would be a chance that some of these might be processed by our office before we knew that there was, a water court filing, because maybe the water court hasn't gotten their stuff out, and, you know, it's hard for us to cross-reference with the water court. So this section seeks to allow our office, that if we determine that while we are in the phase of examining the, registration, to see if we're going to issue it, we can reject it if we find a duplicate file with the water court. If we already issued it and we find a duplicative file with the water court, we can revoke the issuance. That's what this sub 2 is intended to do.
Can I ask a dumb question? Does the water court have a reciprocal process for us?
They do have a process for identifying duplicative water rights that are in that group of water rights that are all pre-1973 statements of claim. And sometimes judge and site specific, a judge may toss a water right out for being a duplicate of another water right, and not supplement it. But that they don't look forward though, like we would be doing here, and we would not be revoking the claim. We would be revoking the water right that we issued. Okay, just as a clarifying point.
Couple,
This one
is the term state-based registration defined. So somebody, somewhere the public reading the rules knows what that means.
that's what we're trying to do in one.
I mean, as a definition.
We could change that to make it look like a definition instead.
Well, so James had a comment earlier in this document to put that in the definition section of the WPMPs. And so there was conversation to put that in the definition section of this document, the state-based registrations
State-based
definition. Yeah, yeah.
So at some point, when we see what that is, and then my next question goes to as you're describing it. And it's just a question, so that, what that does is put the onus on us, on you, to determine whether or not there's a duplicate file. Should we be putting the onus on the applicant? To know whether or not there is a previous filing, so that they can avoid that upfront, and that then if we find something, we can just, something comes up later.
I think,
I'm just trying to, I think, on my mind, simplify it. We're not having to do that background research on every filing. That should be on that.
we're gonna do this research regardless. The reason that this is kind of brought up in here is because it is, does specifically look at pre-73 rights. Down lower in this section, you'll see that we have a similar process where, although it might not have been something that was filed with the water court, if you filed a registration for your house, but you already had an active water right for that house, we're not gonna give you a new water right for the same use out of the same well, we would consider that to be a duplicative water right. Also, the difference is that it doesn't have that specific tie to something that the water court's doing. And here, the other difference is that since we don't know what the water court will ultimately issue, we may need this additional piece of clarification to revoke an already issued water right. But, we're gonna look to see if there's duplicate water rights or duplicate filings for every one of these, no matter what. And most of the information that we're gonna find is gonna be in the same database, with the exception of things the water court might not have put into the database yet.
Okay, so the state-based registrations, that's information coming to us from the state. That's the file that's that in the office and you're starting to go through them.
Yes, sir.
And those were accepted and generated by the NRC. Well, the NRC didn't already do that?
No. They have done some preliminary review, and in some cases, they may have identified that it might look like a duplicate. We haven't looked through enough of those to identify all of what they did identify yet. Sorry, it was a little wordy, but what we really want to do is make it clear what action we would take. Regardless of who found it,
If you want, yeah.
we got a note to file from DMIC that says that it looked like a duplicate or whatever. We're gonna ultimately look to see if we think it's a duplicate, because we're the ones in the hot seat for making, for either rejecting or issuing the registrations. So,
And those registrations remind me of the winter.
from the mid-90s, all the way up until the effective date, there were filings that had been filed with the Montana DRC for 602 groundwater wells, for 605 stock water, and then there were also unfiled ones, which there was a period of 180 days following the effective date where people could file not only for their 602 or their 605, but also for these exempt uses, which is not to be confused with a permit exception. Exempt use is something you just didn't have to file a single piece of paper for. Okay, so
The registration filings then also included permits that
no,
they filed with the state after.
and if the registrations have anything that would be, look like it should have had a permit, like a new appropriation permit, something more than 10 acre feet, something more than 35 gallons, but those kind of standards, and more nuanced than that, but then we would suggest that that's a relevant form filed, and there is a section lower in these WPMPs that does address, if we find something that was filed and looks like the wrong form filed, what would they do? And we would reject that also.
More technical than you probably need to be right now, but I'll talk to your head, how are you gonna go about doing that comparison?
We have an office map and a checklist, and whenever we go in and do the work, we can look to see if that geocode has other water rights. We can look on this water rights tool called Converge that has a map involving water rights. We have technical tools at our disposal to get pretty close to seeing what's out there. Again, though, some of those things may not exist yet because, and that's why we have this subdivision. And so that later down the line, you determine that there is something, I don't know that we're gonna go looking through things again after we issue these, but if we come across them again, we want to have the ability, and we may have a phase where we look at everything that was issued in the decree for 76 LLJ and do a crosswalk. Right now, that seems to be a lot of our capacity, but, you know, down the road, maybe. Should we, go on, or, did you want to talk about Haley's?
Yeah, sure.
Yeah, I mean, my comment was more so just to make sure that it wasn't impeding on the water court adjudication process. Mainly because I just got stumbled up with the use of terms within this section. So I understand like what the need is, but I was making sure that it wasn't interfering with the water court adjudication process.
And does it,
I mean, if it's really directed at, what Ethan's suggesting, then no, I mean, it brings up a question that I've had, for a long time now of, you know, how is this body going to establish a relationship with the water court, similar to how DNRC has a technical relationship with the water court? And I think that's something that we just haven't explored yet, mainly because these basins just opened up, for adjudication, so, you know, how is this body gonna get information on how the water court proceedings are going, right? That might be, something that this office should know, right? Like if there's a individual who comes in and they're confused about what's going on, this office would at least understand, you know, where that process is, what's happening with it, and be able to better direct them. So it's just kind of reopened that thought that I've had on how to establish a relationship with the water court for this.
so is the language okay? And do you have a thought on maybe tweaking the language?
Yeah, I mean, I just get caught up with the filings made to the water court piece. Yeah, I mean, that confuses me to where it's something like the registrations are supposed to be filed with the water court. And so I'm just thinking, trying to put my head in like how somebody in the public would read it too. And that's where my mind first goes, is that this needs to be filed with the water court type of thing. So my suggestion would be to alter that somehow. I don't necessarily know how to address that right now.
So Haley, what is our current relationship with the water court?
I mean, we don't really have one. We're kind of in the background, on a lot of this stuff. I mean, the compact parties speak for the board, in front of the water court. I wish that relationship were better, quite frankly. But it's something that we can always build on.
So it's only may compare registrations, one with filings made to the water court. I mean, just having the language filings made to the water court during the identification in there, you know, the member of the public might get confused by that, but it's seems clear enough to me, it's that we may compare with that. Not that we're going to do anything with, or that we have any order to do anything with water court filing. Roger.
I think that's a really good point. I think two things. One is that down 2A and B may reject it, so seems like we should have a little bit of language in there saying something that we'll contact the applicant to make sure what their intent is, so that, you know, you might have one idea and they might have another idea. If you throw it out before we get any input from the applicant, then that wouldn't be a good deal. And then I guess, yeah, I think maybe we should have some sentence in there saying that the filings with the water board are currently being adjudicated and are given prima facie value or something, you know. I guess this whole this whole thing right now, I guess to me, I'm just gonna say it. I thought we don't have this in our packet. So to look at this now without having reviewed it first, I have a little problem with that, you know, because I'm just digesting all of this now, trying to digest it all now. So this one especially, I think maybe you could take our comments and come back with some revised language or something.
On this section, sure. Which I think is appropriate. I think that was kind of the intention, either we give it thumbs up or thumbs down for now, and thumbs down, and it doesn't go out to public comment. We review it home. Yeah, which is fine. Thoughts?
Yeah.
Agree or don't agree with pulling off, and we're trying to either give a thumbs up or thumbs down at this point. It sounds like Roger's kind of wanting to thumb sideways, and so at least give us a chance to review it.
I guess my question would be, if we don't have consensus on it today, how does it affect the office and the staff? Or does it not right away? Is there any urgency on this?
We do have a box of registrations that have timelines on, but this particular, like, I guess. You also do have a 15-day, you'll never modify things to you, so it's not exactly like, if you send it out, you couldn't make additional modifications. In terms of that particular section about the water quote stuff, I don't, that one's not gonna bite me too much. But, you know, if, some of these other ones I'd like to, hopefully they'll get a little better traction on it. And is this not, do we not send this file
It's definitely on our website, but we had a message for us.
Maybe sort of trying to consider what you're saying, really. If I go back to just reading even the title of it, maybe that would help clarify it, is because it says determination of duplicate water court filing. To me, that implies you've got duplicate water court, duplicate filing in the water court. That's not what you're saying. That's really not what this is. Determination of duplicate water court filing.
I'm kind of working out some language right now that might resolve this. So if we want to continue to move on, I can maybe get this revised language over to Sydney, you know, within the next like 10 minutes or so.
Okay.
So what are you saying, Clayton, that if it was just clear in the heading, determination of water rights filed with both water court and FRWMB?
Yeah, something, because just the heading itself, I mean, the rest of it seems like I could.
Pretty straight.
I could give a potential thumbs up too, but even if you just look at that heading, I go back to that termination of duplicate water court filings.
Should say state-based filings, but
Yeah, maybe it's,
why don't you go to the definition of state-based, if we wanted to look at that?
yeah, well, hold on, yeah, let's do that, but I'm just. Again, thinking out loud, so it's really determination of. I mean, it's a longer heading, but it's determination of.
a duplicate filing.
State-based registrations that. or the duplicative. That have a duplicated water profile or something, I mean, it's awkward, but that's more what I'm driving at as opposed to what it says. Which thing that mentioned the kind of duplicated water profile is actually clear. I mean, I don't know, Ethan, does that make any more sense? I don't know.
That can work for me.
Anyway, so the definition of state-based registrations, if we want to look at that, is a, you want to pull that up?
We've had Jesus on.
Up higher is where the definition of the state-based registration, no, memo, it's highlighted. But then- And there's a desire to rephrase that as a definition as well.
Well, yeah, if there isn't already a definition, we should come up, I'm just saying, if there isn't already a definition, we should maybe come up with that definition, define state-based registrations.
Yeah, so we do have a definition of that. That's within the MOU between the board and the office of the engineer for the state-based registrations. That was something that we categorized at that point. So we could take that definition from that MOU and put it into the WPMPs.
Is that handy? Can we see it?
I'll pull it up. I'll see if I can find it quickly.
Why don't you highlight this whole section and say, replacement definition from, OE board, no, just that one
And
second.
I'm not even, I mean, I don't know, like, I don't know if it's meant to replace it, just that as you read this, if there is a definition of state-based registration somewhere, that would be helpful. So while she's looking at that and then looking at, the proposed language, we want to move on a little bit so that they can work through that, but I wanted to ask another question. It goes to again, the registrations and what you described as what the registrations are.
Yep.
So if permits are not in that category, what category of permits?
Permits that were filed for during that CI,
Yeah.
there's a list of them and they are unresolved. They are not resolved by the Water Rights Compact. They, it's a one-off discussion topic that, the state wants to talk with us about on how to communicate that with people that didn't file, but there is no, pathway for a handful of filed changes, permits, replacement wells. Obviously the replacement wells can be solved now because there's a new process. And presumably, once you have a permit change process, in order, then we give those former filers an opportunity. If there's not something set up like these state-based registrations or registrations of the tribal water right that have a defined pathway forward for existing uses that existed before the effective date of the compact, for our office to take a look at those and move forward.
So we still have to talk about, what's the volume of that?
I have a spreadsheet I can share.
I'm just curious, it's helping to clarify for me, because
Maybe
I guess
35 or something, I think is but out of the 35, there's, most of those are replacement wells and less significant than like a full-blown permit application.
okay, all right, Roger.
Yep, and then with that CID ruling, the DNRC did quit issuing permits and changes. So there really aren't anything hanging out there like most people did was like the city of Ronan, Folsom. They filed a replacement well, needed to drill a new well because it took them offline, and they filed a replacement well, but yet. You know, it's been since Seattle, that's been 35 years, so there's been some growth, it's massive. And so their place of use has enlarged also. So once we get a new permit and change policy, then we can address those.
Yeah, I would just, in the back of my mind, I thought for a while the state was actually accepting and taking their money for the soil.
So that,
And telling people that they're on hold.
Yeah, mostly what they did was the DEQ required for a new well, or to replace a well so that these cities could have a viable water source. They let them drill it. The DEQ at that time required them to show a water right. Well, a replacement well gets a water right for DEQ, and so that's how that triggered. But now we need to build our permit and change process so we can go back and clean those up.
All right. So let's, so when you started talking, even you said 106 and 107. Do you want to jump to 107 for?
yeah,
And then during your introduction, you said 106 and 107, but I see here a 108 also. So is that not part of this discussion or not?
there's 108 as well,
Oh, okay, all right,
which is failure to register an existing use.
all right, so let's go to 107.
The first item on 107 is the adequacy of state-based registrations, registration processing. Okay, and under this, we try to like itemize the things that we think are process oriented that are essential for applicants. Registration, registrars, I'm not exactly sure what you call them, but we had a little bit back and forth between whether we should call these a registration or a registration application or registration form. So we try to like just go to registration. There's probably a couple of times that we might have missed one application or something in here, but first item is that we can reject a registration if the registration does not comply with WPMP 10-1033. That is the existing WPMP that we already approved, that just talks about the legibility of the applicant information. So if they have filed something that's not legible, it can't be read, you know.
Why don't you scroll up to 103 so we can see what it says?
Mr. Chair.
Good.
I need to step out to return a phone call. Okay.
Three.
So this is for our current process though, right?
Yep.
You can scroll back down.
And just so you know, our office can read it, we moved.
Yeah, but right off the bat, I have a problem with that because 103 didn't exist when these people were filing their registrations. They did their, I mean, what we've created is pretty arduous process to go through the R602 process. And that's not the same as what those original filings that were. So I don't think that's fair to compare apples and oranges.
I get it. What I'm wondering though is if just the wording may reject is adequate, in other words, it doesn't require them to reject,
But they can't.
but yeah. So how would you fix this?
I guess I just then go to registration defects. I don't like A. I would strike A. I know. It just arbitrary, not arbitrarily, but to go through it and, not allow somebody just, I mean, it's our decisions.
Yeah.
We're making a decision, but it seems like
So
they've submitted something to the state in best faith scenario that now we just kick it out the door. I don't.
Well, we don't kick it out the door, we write them a letter and
That's
see
it.
if we can, if we can, read their address. That's what A is really getting at. The problem with some of these might be that we just can't read. Where they came from.
So based on what you're saying though, strict reading, which is said may reject. I mean, technically, it doesn't say anything about will communicate with the registry. If. If you're gonna write them a letter, we need to probably. Say something in here that says we're gonna communicate with them if we can't read the darn thing.
Well,
That's under B.
the reference to WPNP 103 is what's given me the consternation, because that did not exist when these people filed their applications.
Right.
And that's way more stringent than,
I just, sorry to interrupt, but, I believe, but, we'd like to invite you guys for a field trip with the Jocko irrigation infrastructure stuff. If you're having interest in the overlap with the board, the ordinance, so I sent you some times that would work, and so concentrate on that. So sorry to interrupt.
All right, thank you.
Yeah.
Okay. So let me ask this, if we struck A. Is there enough language in the rest of it that allows you to do what you need to do?
How about we replace, say the OE may reject, registration if the registration is not legible.
It's registration, what?
Is not legible. I personally didn't want to put WPNP 103 in there either, but James really did. So, but I do want something, if I can't read it, I can't do it, and I will try to reach out if we can read the address. But if we have, a filing, and I haven't looked at all. Thousands of them,
how many are we running into that are illegible?
so far, we haven't eliminated.
Well, even if we change the language to what we just said. Part that catches me is may reject. It just simply is, you can reject it, I mean, it doesn't tie to anything. Doesn't really tie to B, so at that point, if we reject it, there's nothing. There's no indication that. There's gonna be any communication with the registry.
Doesn't B, find it all, address legibility?
Sorry, what?
B addresses legibility.
Okay.
Meet criteria set forth in order through, I think it should be done WPP, but I think that addresses legibility and other defects.
Let's just delete A.
And that was my comment to the right as well. Was that could just be a general like housekeeping defect that you could write in a defective registration form letter?
And then, though, if it's not corrected, I mean, it still has to be some. Or to reject something if it doesn't, we just can't use it.
No, that's already listed in the ordinance. That whole process, that's also what my comment to the right is I don't think there's a need to rehash what the ordinance already says. I mean, I think there is legit use for I and little I, cause that's not spelled out in the ordinance, but, as far as the office being able to issue a defect letter for whatever it deems to be defective, that's in the ordinance already. And then, so they're supposed to submit a corrected registration form within a certain time. And then at that point, the office can look at that again and say, no, this doesn't muster up to correction, we're gonna reject it.
You said I and little I, so triple I is then out.
Oh, I guess I forgot that one, but I was mainly looking at I and little I to be kind of the drivers of this section, so I think that's important.
So triple I then does cover the failure to register and respond within the required time frame. May result in no rejection of registration. So let's start, I mean, this is maybe a good time. So let's say we get to that and we reject the registration. What does that mean? And what does that mean to the applicant? And what authority, and ultimately, what authority do we have to reject that registration?
If the registration doesn't meet the terms of the ordinance as clarified by the WPMP, the ordinance itself does give us the ability to reject it. And so, really what we're trying to do here isn't to like clarify that we can reject them, it's to clarify, when we would and what the requirements are, and to clarify this timeline for where we're gonna send defect letters to the owner of record. And then, does, if we're ultimately gonna reject it, we would, after we sent out a defect letter and they didn't respond, or they didn't respond adequately, we just couldn't get a hold of them. That is where we would, if we don't reject it, it gets issued as is. So, I mean, that's another part of this that you have to understand is that if we get past our timeline and we haven't done what we're supposed to do, it becomes a water right. So that's why I'm trying to.
So if they respond and say, yeah, I need another 30 days, maybe that's their response.
We have process for that, yeah. I mean, that's responding to me. And, we have deadline extensions and it gets us out our timeline, and that's fine. And we're happy to manage things like that. And here, we wanted to make it clear that we weren't gonna really start this 30-day deadline for the registration defects until 15 days from the date that the registration letter was mailed. So that we have a nice fat buffer, because we recognize you can't like go back and refile one of these. And we're trying to do what we.
So you're starting to review the registration now.
Yep.
How, just generally, how's it going?
We're taking the stuff out of the water engineer report, but we have
general.
10 of them done, and we are very actively developing processes. In addition to these policies that we need, we are also, figuring out our scanning and file management and checklists for internal review and just the cadence of moving these along. And so that's kind of where we're at on the first batch. So we made it through 10, and we have gotten our process is very well developed and very really started.
So Sorry, I had a thought, but I lost it. I'll find it, I'll find it.
All right, I'll just keep talking. So just shut up.
So are we thumbs up? So this is 7. Okay, all right, let's just keep talking through 7.
So the issue,
Oh, my question is, sorry. So these registrations are from years ago. You're gonna try to get hold of people who assume that people still own them. Or around the same address and everything that they're providing, is that? We're not,
so they have had ownership updates done to them if they were received before the effective date. And I am actively engaged in a process with the NRC to convert all of the 180-day received registrations from their current status, which is pending, to the same status as the older ones, which is suspended. And the reason that I want to do that is because then they will automatically go into DNRC's ownership update process. Whereas we have asked DNRC not to do ownership updates on our applications that are in pending status, because we have a process for our internal application reviews that are pending, where an applicant needs to come to us and then they do an application owner update. And so we really had to separate these groups of pending uses. We could put this pending group over into the suspended right, then we'll engage the DNRC ownership update process. It'll help to eliminate a lot of the problems that we know that that's a problem. And we are all very good at sleuthing the ownership of these records. I mean, this staff is like,
I get that.
you can find yourself.
You answered my question. That's good. All right, good.
All right, registration issuance, you know, after much debate and how I'd like to save money on the mail, we've decided we're just gonna mail. Our mailing budget's gonna go up a lot, by the way, because of the registrations, just so you're aware. Every defect letter, every correspondence, every issuance takes paper, takes postage, takes envelopes, takes staff time. So just be aware that that's something that we're metering right now, as we go forward.
That's probably important because individual registrants are going to expect something in hand that is their legal document at that point.
And every time I bring up the idea that we would just post it on our website, I'm reminded of exactly what you just said by everybody that I pitched that idea to. So I have conceded to try to save that money. We will send it. Well, we assuming you approve this.
Yeah.
And similar, if we reject it, you're gonna get a piece of mail that says you didn't make it. So that means at a minimum, there'll be a piece of mail for every one of those. The rejected ones will also have defect letter mailings. So
We've gone through the process, made an effort to contact somebody. They've responded or not responded. If something has happened, you reject it. Is that decision appealable? Is that something that they have an opportunity to come back on and say, I'm sorry, we're still here, we want to fix this?
Yeah, I mean, if the office of the engineer rejects one of these, they can appeal it to the board. Mhm.
That's an option.
Mhm.
So I have a question. So when people file these things, there was a standard process to do that. Is your review process any different than what's the application process?
no, it's pretty similar. Yeah, it's it. All of those things tie to it. And we are not gonna try to to reinvent the wheel as long as we adhere to the ordinance standards. But I also do know that many of them have significant defects. And so, I mean, I'm not trying to say that those can't be resolved. I'm gonna try to resolve them when we can, but. You know, it's not like, oh, we have 1,000 perfect water right filings. You know.
Nothing we do about that, I mean, we're going through the process trying to make it right, but it's still, I guess, so it's me that the NRC should have been doing that all along.
Well, and you have to understand too that those were all filed too before the compact was ratified and the effective date, right? And so the review that they were doing was what they've been doing under the state. So the due diligence of reviewing it against the ordinance has not been done. So that's what the office is in charge of doing.
Yeah,
So,
I'm just fussing.
no, I get that,
NRC
but that's probably why they
should have
did.
been doing something that would have corrected defects as the applications were made.
Well, that's what I was getting at, is that's probably why they weren't, is because that authority
This
is
is
not
coming.
theirs.
Yeah.
Right.
They felt nervous enough doing the pre-look at them, but owner contact would be. That's a whole different realm.
All right, enough fussing. So adequacy, so where are we at? Adequacy. The
So,
WPMP indefinitely 7 to 12, is that any different than what we just talked about?
yeah, that's the section that deals with ownership. And ties into possessory interest. All these have the same, you know, I mean, our possessory interest standards are pretty similar to the Montana DNRC's possessory interest standards. And so we really adopted, for the most part, everything that they're doing with us. So if you're got an LLC, you have to show us that, you know, your LLC is in good standing, which if it's a Montana LLC, we can usually find that on our own. We don't even, we're not gonna kick a letter out for that. If we need to know who was able to sign on behalf of then you won't have to give us some of your articles of incorporation, you know, this kind of stuff. You know, and it also, it makes it clear that if we received registration filing that's on somebody else's property from someone that doesn't own it, or has a well drilled over here that doesn't include that parcel's, you know, a letter approval or a signature from that person, that's a problem for us. And that, you know, that's not any different than it is anywhere else in the state. This is you know, it's a private property state, and you can't just apply and get water rights for things that are on other people's property without having their express written approval. So this second,
Then going down to the next page where it starts additionally, registration, blah, 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 so. WP 10-103, 1, 6, and 7. Is the wording, but excluding requirements of 5 necessary? If you were specifying 1, 6, and 7, I don't know, I'm just asking.
you know, I write in belt and suspenders.
So,
And
so how important then, what is, why is it like
That was James. I would never write that. I don't even want that whole sentence in there.
Okay, well,
which one?
the additionally part,
Yeah, I mean, it's just confusing. I'd rather have it just written out instead of the references to that.
Yeah, I guess I come back to my comment from above that. We heard previously that. WP and P 103 didn't exist when these filings were in place, and I don't, and, you know, to look at this now, I wanna go back and see what 7-12 is, but 103 (1) is, I don't, you know, I think, I guess, I wanna, if we're gonna, I guess I'm not gonna give this a thumbs up till I do more of a thorough review on what these cross references are.
Can we do it now?
How much more of this kind of stuff is there, people? I mean, are we better off to come back to get this in writing from you so that we have time to look at it and digest it and bring it next meeting? Or, I mean, we're at 3 o'clock already.
Sure.
We're not even through item 3. We're not even a third of the way through item 3, so.
Well, this other one coming up is kind of timely for us to look at, right? The one on abandonment,
Yeah,
given the public comment that we got at the beginning of the meeting.
It's shorter. So,
So what I heard you say to start, we're gonna go through these and any of these that we give thumbs up to, we can put out for public comment.
Well, we need board action on that.
Right.
Yeah.
But we can put out for public comment and any that we don't, that we give thumbs up to, then we hold for further review.
yeah, you can just table 21-106, 107, 108,
Okay.
and not include that in anything that was gonna get released. And so far, I do have you down for okay with the first two items, the deed of trust and the reservation water rights database.
I have those checked, so let's hold off on 21-106, 7, 8. Further review. Let's jump to, can we jump to the abandonment one? That seemed to be a critical one from today's discussion.
Sure, so here, there's two sections of the ordinance that really deal with abandonment, which is, and you'll remember, we have the parallel structure for the WPPs. And so under 2-1 21-1-11, exactly what it is, but we have the abandonment of the appropriation right. I have three items that I thought should be clarified. The first item is evidence of non-use. And so the abandonment section looks for a period of 10 successive years of non-use of an appropriation right for determining abandonment. And this just makes a clarification there. The OE may use historic burial photographs for purposes of demonstrating a period of 10 successive years of non-use.
So I have the issue with number 1. Because it seems to say that's the only thing you can use, is historic area photographs. I mean, there's other like verbal testimony, other types of photographs. You know, evidence on the ground. It's, you know, I looked at the ditch last week, you couldn't tell that there had been a ditch there, but there actually was. And I asked versus how long it's been like this, he was about 20 years. So,
Well, this wasn't intended to be exclusive, and it's was supposed to be permissive for this particular, but if you could, we could rewrite that in a way that doesn't give you the impression that it's exclusive. Be happy to.
And that was gonna be my question also. So you have language you could.
yeah, it doesn't have to start listing, things, you know, I think list. So I just say,
Just say review.
there historic or other aerial photographs or other evidence of, or not just evidence, other
Other appropriate information.
for evidence.
Documentation.
Huh?
Documentation.
Documentation, yeah. Other evidence, I don't know if you want to say admissible evidence, but
I'd rather not.
yeah. I just say other evidence.
Yeah, it opens it up, and that was gonna be my question, air photography, if we just say only air photography, because I just. People who file. We're looking at abandonment, it's typically something that was probably, an old use, old point. And sometimes when they file those, they use lots of other sources of information. To actually make the filing, and that information might be relevant.
Sure, yeah. Should jump to next one.
With some.
I'm just reading.
Yeah,
Right, so, in addition, the ordinance language about the 10 successive years, it includes, when water was available. I think is the language, and here I wanted to make a clarification that failure to maintain an operable diversion does not equate with water being unavailable. Which I read from the ordinance to be more of an issue of supply, not failure to maintain a conveyance or diversion.
Again, I think that's just too black and white. I think it's maybe not necessarily. Not necessarily equate with, what if it really does show intent? Then there's no diversion there.
so, yeah, so,
Well, that is different, like if they actually remove the diversion,
Or let it rot, so it's gone.
but we're not trying to say that failure to maintain the diversion, doesn't mean other things as well. But for us, I just wanted to make it clear that that doesn't equate to this water availability issue. But
so why say that?
I say,
Why this? 22?
cause I think that there could be circumstances where someone says, well, water wasn't available. Because my head gate's been buried under for 15 years, and I don't think that is,
You mean so if I'm a water user. and my head gate's buried, water is available. You're saying that the water user themselves might say. Or saying what? That
the water wasn't available. After I diverted
they're
it,
saying water,
broke the head gate.
they're saying water not available. Therefore, it can't be abandoned.
Yeah. Because the ordinance language is two-part, you have to have it in front of you. That'd be great to just read it directly, so I don't butcher the quote. But it's not just 10 successive years of non-use. It includes this phrase about water being available.
Yeah, so if an appropriator, other than a user of any portion of a tribal water right, ceases to use all or part of an appropriation right or existing use, or ceases using the appropriation right or existing use according to its terms and conditions for a period of 10 successive years, and there was water available for use, there is a prima facie presumption that the appropriator has abandoned the right for the part not used.
And I think that the clarification about the water was available. I mean, I think that was really like the source wasn't dry. As opposed to. I just didn't maintain the line.
So it seems like this one would really have a lot of bearing, for instance, on the public comment we heard today. Right? They've had this water right for a really long time, but never utilized it until now. And that seems to be the basis of the concern. Or am I missing?
We don't know if they never used it.
Well, it's also a little different, because there's no evidence, at least that's presented or whatever, to suggest that water wasn't available. There's, the concerns that they're raising is that they just haven't used it and now they're gonna go back and try and use it. So it's not necessarily that water wasn't available or was available, which is a different component.
And it's,
So,
and it's not the applicant making the point.
yeah, it's the
Neighbors.
neighbors, and but.
Right.
That's the perfect segue, because doesn't there have to be a demonstrated intent to abandon?
There's two parts to the abandonment clause within the ordinance. So there is if there's evidence of an intent to abandon, then yes, that can be just like full-blown abandonment determined by the office of the engineer.
Yeah.
But there's this other piece of it that goes to the 10 successive years of non-use and when water was available. And that's a little different. So there's kind of two parts to it. There's like clear intention, but then there's this other 10 successive years of non-use.
It's nuanced.
I'm not sure what that paragraph's even necessary.
This was,
Disagree with one, I just don't see it really doing much. It takes away your discretion. And I'm sure you want to give away your discretion.
Yeah, I think that was my conversation with you and we were talking about this this is kind of getting more into like the facts of it, right? Which you want to keep for yourself to have that ability to decide whether it weighs in on the facts or not. There is something that I did talk to Ethan about that the board might be interested in is there are some recent cases coming out of the Montana Water Court to suggest that if the natural channel of a stream or river changes due to drought conditions, then the appropriator still has the obligation to make sure that the means of diversion are operable. So whether that means, they have to get a 310 permit to move the means of diversion, that's something that the water court has considered to be still an obligation of the appropriator. So just an interesting little thing for you guys to be aware of.
And, Ken's. Take Ken's comment, understand, yes, where I'm at with too is. Just that maybe the language could be clarified a bit, but I'm not. Quite sure how to clarify it right at the top. Because I think I'm getting the gist of the why.
So even if 2 was removed, would that make your job easier or harder?
I wrote to, because I think it is a benefit so that if I had somebody in front of me and we were discussing 2-1-1-1-1-3, which is this, 10 successive year period and water was available. And they were going to argue, well, water wasn't available because my head gets broken. That the intent, poorly executed or not, was to suggest that I believe that the water owner has a responsibility to maintain their head gate, and failure to do that does not you know, that's not part of this water available, because it's an and. 10 years successive non-use and water is available. And I'm trying to figure out a way to separate the natural availability option from an anthropogenic availability option, which is just eruptive explosion.
So why don't you change does not to may not? If you really want to leave that paragraph.
And what if you said alternative incorporated into the diversion? And then from there, that could be maintained to perpetuate access to water is deleted. Is that? Okay.
That works for me. Yeah.
13.
Any other comments? Number 3, yeah, right,
Oh, this is going on.
number 3.
Go ahead.
Sure, there's also a provision in, the abandonment section that, you know, sets you out of the abandonment. Eligibility for abandonment if you're actively engaged in a, candidate conservation agreement. So if somebody gets into a conservation agreement and then, you know, part of their conservation agreement is, you know, you're not gonna irrigate this field for 10 years, hypothetical, okay? Let's say 11 years. And there's water available, 11 years goes by, that candidate conservation agreement would exclude, any kind of an abandonment, determination under, G-1-111. And, my thought was, that's fine, but, you know, if that exclusion is gonna be used, could you just provide us some information about it? That's all, just trying to say, good deal, let's see it, see the papers and move on.
So it says. The candidate conservation agreement as per ordinance 2-1-1-4. So a candidate conservation, the ordinance 2-1-1-11-4 has to do with candidate, a conservation agreement.
Yes, that is the part where it says if the water right owner is part of the candidate conservation agreement.
That part of the ordinance contemplates abandonment with a candidate conservation agreement, yes. It's like 4A through B in the ordinance. Yeah.
I need more clarification, I'll say it again or something, because I'm trying to understand why as per ordinance 2-1-1-11-4 is in.
Yeah, I think I don't like as per, if you want, you could say as referenced in ordinance 2-1-1-1-1-4. I think it's just trying to tie back to the fact that candidate conservation agreements are contemplated under the abandonment procedures within the ordinance. So he's not making up anything new here. All he's doing is requiring that the appropriator shows proof of the candidate conservation agreement. They can't just come in and say, oh yeah, I've got a candidate conservation agreement, believe me. No, you have to show proof of that agreement. That's what that's getting at.
So I'm being, so let me further suggest then that as ordinance 2-1-111-4 actually goes at the end of that whole section.
Yeah, I mean, we've also done two where it's like the sentence is complete and then just put ordinance 2-1-114 sub 4.
There.
We've
Because I
done
think
that
the
too.
way it's written,
No.
because let me tell you what I'm reading. As appropriator who is part of a Canada Conservation Agreement. So as per ordinance, so this says that to me, as a reader, that the Canada Conservation Agreement comes out of ordinance 2-1-114. But it's not the conservation agreement that comes out of there. Right?
Yeah, so maybe we should say something like an appropriator who is citing participation in a candidate conservation agreement as referenced in ordinance 2-1-1-1-1-4. Like that instead?
Well, I actually like
Just do
put it
C,
at the end,
yeah,
just put it right at the end.
so delete that
Yeah,
and the comma. And then take ordinance 2-1-1-1-4 sub 4, 1-1-1 sub 4. Copy it. Put it at the end of the
Yeah.
sentence.
yeah, okay,
And then period.
that's what it is intended.
Delete the comma. That's fine.
The only other thing I would want to change in this that I notice is like, I don't really want to see those all the time, just if there's a hearing about the abandonment of that right. Does that make sense?
I couldn't hear part of it.
Sorry, I don't really, the way this reads right now is almost as if anybody who gets involved in a candidate conservation agreement has to bring this paperwork. I really only want to see the paperwork if the use is part of a hearing.
Well,
I mean,
is that what 2-1-1-1-1-4 does?
Do you think it's infirm?
Well, it's under that section though of the WPMPs as well, so I'm kind of confused now.
Okay. Well, no, I meant like. This makes it look like our policy is that. No matter who is involved in a candidate conservation agreement, everybody would have to believe it. I only want to see it if the water right. Relating to the conservation agreement is, being challenged for abandonment in a hearing.
I disagree. I mean, it's under the abandonment of appropriation
Yeah,
rights
that's-
section of
That's what I
WPMPs.
thought, it's under the title, and,
All right, good, thanks.
but
Yeah, and it's not ordinance, this is policies and procedures, so. How you apply this,
Thank you for helping me work through that.
So I have
yeah,
number one, I don't know where the word candidate came from, it's not, or.
Yes, it is. Yeah.
But I don't see it.
Give me the reference. So if you go to 2-1-1-1-1,
Yeah,
and then you go down to 4. Says if an appropriator ceases to use all or part of an appropriation right or existing use in compliance with a candidate conservation agreement. Initiated pursuant to 50 CFR 17.32, or because the land to which the water is applied to a beneficial use is contracted under a state, tribal, or federal conservation mitigation or set aside program, and then AB.
it's incorrect, but still, it addresses other things other than conservation. Like conservation, mitigation, or set aside programs.
yeah,
What you've done there is limited to just conservation agreements. And I'm not sure what the difference in those three things are. But that is what the ordinance says.
well, they have those, the NRCS had those programs. Where you would take your land out of crop. And put it in fallow and just leave it, so.
Yeah, like the CRPs.
What is
CRP.
CRP, thank you. Crop rotation program, I think is what it's stood for.
Yeah.
And so naturally you wouldn't irrigate, because you're just setting it aside, they were paying you big bucks for not farming, so.
All I'm saying is that I think we need to reference all three.
I get, well, or scratch that out of there because it's all included in the three, right? Because you're doing it all under ordinance 21113.
Yeah.
Four. So if you just an appropriator must provide OU with a copy of blah, blah, blah. And then you cite 21114. 21114 capture all of those, right? I mean, is that what you're saying?
Yeah, you just want a copy of those agreements or contracts, right?
Yep.
Yeah.
Yeah, I think one of the earlier versions did just reference, an agreement as per ordinance 21114. I think through our editing, see if we got changed to candidate conservation agreement, but, I really, the most general way that we could just reference any of the agreements set forth in ordinance 21114 would be the easiest, so maybe an appropriator who is part of an agreement instead of say an agreement.
I leave it at conservation agreement because conservation is just an adjective, but in this case, that's why you're doing it. It's a conservation.
That's fine, okay, so that would be a part of a conservation agreement, so.
Conservation agreement in general, because they're all those are formed of a conservation agreement. Is that-
I don't know, I would say conservation, I said an agreement as in section 114, and that covers all three.
Yeah.
Yeah,
I would also say, so that part of an agreement or contract, I mean, because it also contemplates contracts too. Sure, a little bit different, or could be.
you gotta change the title. Proof of agreement
Or contract.
or contract, agreement or contract.
So we need conservation for time. And at this point, I would rather move the ordinance reference. Back up to after the contract. So, undelete the ordinance language, yeah, delete that. Undelete that.
Reject change.
It's okay, we can get this cleared up later, but, would you like as described in ordinance or as
Set forth.
set forth? As set forth, yeah. Thank you. This policy work goes fast, doesn't it?
All right, I just got that conservation area down below too, so the whole next sentence, or that whole sentence needs to be.
Yeah.
So one other thing, maybe you could just, where it says comma, which should. Just say that details. Then add an S. Yeah.
Thumbs up?
Yep.
Thumbs up.
The next bit is, it goes into the procedures. And there's, two items in there. It talks about injury, and it talks about a little bit about water supply, and, I made these clarifications because I think when I read the abandonment ordinance, that the main focus is really on the lack of use, possible intent, and that issue about the water being available during the 10-year period. What I do not want to get into, in the hearing would be having somebody who is a petitioner have to provide extensive evidence of injury or extensive evidence that the water supply is, being detrimentally affected. And so my suggestion here was to try to say that the claim itself will be prima facie evidence for purposes of this abandonment here.
I would pretty much strike most of that.
Yeah.
And just say that an appropriator claiming imminent injury under the ordinance. Possess of a claim of injury related to appropriator's legal use will be considered prima facie evidence. I think when you start talking about extensive adverse effects and all that, you're really making it, teachable, was extensive.
Yeah, that's great. You want to clarify that for what's okay?
Great to do that. Do it, Ethan. Later, you're better at that. Okay. Okay, strike everything between ordinance 2-1-112, starting with does. Down to. Yeah, keep going to the right, no, up. Keep going to the right, strike that. So now what do we put back in? Oh, if you take that of injury, I think that's kind of does it. It's a prima facie evidence of abandonment. Now, having said that, is that too arbitrary?
Well, hold on, I don't know that it's prima facie evidence of abandonment. It would be prima facie evidence of injury.
No, excuse me.
So,
Okay,
so,
Yeah, I was gonna say, are you, suggesting that you just have them claim and all of a sudden it's with evidence of abandonment?
I was hoping.
Which these guys made today, so that's prima facie evidence of abandonment. But it's not. For the record.
Quick save.
So that's a big time litigation, in that sense.
Oh, my gosh.
I said, but it's not.
Do the same thing for the next.
And it was Ken that said it, not me.
I didn't hear that.
He didn't hear anything. What?
No, I really didn't hear.
Oh, no.
I didn't hear anything.
Should I speak up?
I would make the same kind of changes to that.
Yeah, delete that,
And
and then add, it should be Appropriated claiming. Reduced water supply. For some reason, there's some, yeah, that should be reduced water supply, something. And then change the final injury to reduced water supply. Thank you. You do abandon it, these are the only policy pieces related to abandonment, unless you have thought of something else that should be in here that's not.
Let me read them. What do we just do? We're claiming.
You gotta have some evidence to support that. That's just arbitrary and capricious.
What we're claiming reduced water supply. Will be considered unofficial evidence of reduced water supply. What does that mean?
I mean, there's a presumption that the water supply is reduced, and that's a presumption that can be rebutted by evidence.
It's a presumption that what?
That forms a presumption that the water supply is reduced, but the presumption can be rebutted by evidence.
So unappropriated claiming. Injury, I understand, but appropriated claiming reduced water supply. They're claiming their water supply is being reduced, or that the other person's water supply is being reduced.
This would be somebody petitioning to abandon a water right that they think should be abandoned, and they're gonna do it because they think they're injured. That injury is typically because their water supply is reduced.
Well, then it should say a petitioner claiming,
Okay.
not an appropriator.
Yeah, I mean, that's,
But I still don't like it. Still, you gotta have some evidence to show you've been impacted.
I disagree with that. I just think this starts the process. That's all it does. It doesn't form anything, no conclusion, just, okay, now we can start the process.
That changed to one. It says appropriated.
petitioner. Claiming, so how do they do that though? I guess that's gonna be another question. If we stick with that, how do they do it? They just walk in the door. So if you take it on its face, the individuals who are here today made that claim.
Yeah, they have to fill out this form.
Right,
Well, the guy felt, okay.
Yeah.
So how they claim that maybe needs to be included in there. Because otherwise, just making the statement. You're right.
Well, I'm sorry, I got a little sidetracked trying to help.
Petitioner claiming, how do they claim?
They filed the form that you're gonna see in a minute.
I'm just asking, should we say something about that form here, because it just says. Petitioner claim,
Reference form number
yeah,
61-2F.
yeah, I think at the end of each of those, you could just reference the form. I
Okay.
don't think it needs to be spelled out.
okay, that's fine, but I think it's important, because I think. Was it a verbal claim?
61, what was it again?
At the end of each
that?
of the
What was the number you just?
Oh, 6112.
61.
Excuse me, 6112, 612F.
Okay, thank you.
I was like, is it break time yet?
Yeah, we're almost there, and we almost have a thumbs up, but Roger's got something we can tell.
Yeah, that whole prima facie thing, I don't like. Cause it says, the definition is based. Which is a long definition, I guess. Based on the first impression. Accepted as correct until proven otherwise.
Right.
In any other case, it's the objector's responsibility to demonstrate adverse effect, not the appropriators.
Well, that changed in 1979.
It's also a little bit reversed because the appropriator is essentially like the one who is causing the issues. So it's not, like, they would have to come back with rebuttable evidence that they are still in use, and there's not been a period of 10 years of non-use.
But it's, this is saying that I can walk in and say, you know, the city of Folsom has lowered my water level in my well. Or something, and, you know, for abandonment purposes, and then they have to prove that.
Right.
But it should be the objector's responsibility,
No.
I think.
Not an abandonment.
That was law in Montana for about 100 years. That's what we, and then it switched.
Well, again, though, like for abandonment, just, like if there was a hearing on abandonment, it's really just about whether or not that water right should be abandoned. And so the 1 and 2, you know, is really just to say, like, we're not here to debate water supply or injury. Was the thing, you know, not used for 10 years when water was available? Was the thing not used with intent to abandon? That's all so many petitions, that's all I really want to look at, because that's what the focal point of an abandonment situation would be.
Okay. So do you remember when we were interviewing different law firms? And there was one law firm that came in and they went on and on and on about 79 branch. And it was such a terrible decision. This is during the interview. If that was the case, it changed the law. This is what, 25 years after that case is, it's still not about it.
What if we took out prima facie? This is considered evidence.
I have an issue with that because I remember what we're doing here, starting the process. We're not proving it.
Right, so think of somebody coming in and saying, hey, this person's drilling a new well. I know they haven't used this in 10 years, and if they drill this well and start using water, I'm not gonna have water. That is evidence that there's gonna be a reduction in the supply without them having to go get some sort of hydro study done or some well contractor to come out and prove that, right? It's them saying, if they start back up, like, I know my water's not gonna be there.
And when they file a petition, this is what we talked about earlier, this gives Ethan the go-ahead to look into it.
The investigation, which is what I like to see. Investigation.
And I'm okay with that, it just says it's accepted as correct until proved otherwise, so. Then that puts the onus back on the abandonment person.
Well, it's like claims, that was, I first encountered the phrase when we started studying the claims process and the claims process. Claim filed is prima facie evidence that that's a true and
Yeah.
valid and accurate claim.
Right.
A lot of people agree with your dog, but they don't like it. Law really did a flip flop. 1979.
But yeah, you're right.
That's what they did. Don't quote on the date.
So, one last for me, under 1, that last sentence, right there where it says legal use. Does the word legal need to be there?
Yeah, I don't like that. Just use of water is appropriate.
Just say water use.
Use of water use. Yeah.
Yeah.
More correct way to say it.
There's a lot of non-correct language in water law, so,
I know, all
yeah. Well, water law in particular is
Oh, yeah.
phrased so poorly.
You know, well, it's mishmashed over the years, not just here, but in every state. Yeah. Do we have thumbs up? 7 then? Yep. Or no, 112. Oh, where we're at, yeah, 111 and then 12, yeah. Thumbs up. You're gonna go over the next two and then take a break, or you want to break now? All right, take a break. All right, we're on 22-115, correct?
Sir, Mr. Chairman. Item one, redundant well. We're asking for GPS locations. For both, new well and the old well. Item two is that, if applicants are filing for a redundant well, we would like them to provide us documentation from, the government entity that requires the redundant well. Or like if you have a public water supply, and you're supposed to have two wells that produce the same amount of water that is needed for the total public supply, and that's because if one of them gets fouled, you know, we a significant number of people without water, and so it's a design like that.
Yeah, thank you.
Substitute well, same deal with the GPS locations, we're just looking to get that long for all those. When people are filing. That's
So,
it, yeah,
Dumb question,
sure.
and that asks this other big things. If you say GPS coordinates, do you have to add latitude and longitude, or is that given?
Well, I just think it helps.
Okay, I was just
Yeah.
curious.
And we say GPS specifically because I don't want them just grabbing it off of Google, whatever, you know, because that's how we verify whether the GPS locations are correct.
And everybody out there understands what GPS means?
Yeah, most of these are gonna be well drillers that are,
Most.
yes,
Okay.
global positioning system. And most, everybody's got them on the phone.
Sorry. If you're gonna have GPS in there, I would just recommend in the acronym section of the WPMPs, just
Okay.
putting out what it is really, yeah.
All right, we'll get that in there for sure.
Number, back on number 2, I'm trying to think on those. Are required to provide the alternative documentation from the government entity required. So. Blah, blah, blah. Are redundant wells only required by the government entity?
Yeah, typically, redundant wells are associated with a requirement for public water supply, municipal water supply. They can be required by the tribes for a tribal water system.
And so no other individuals can have redundant well.
That's typically the way it works. They're limited to people who are serving larger numbers.
So is all this is a new, this whole thing, 1 through whatever.
Yeah,
Typically required, though, doesn't mean they can.
if you like have a house and you want to have a redundant well, then we don't usually allow that.
Okay, I'm just trying to clarify because it just. Not only applies with states that
It's required to show us that information.
are required to provide, from the government entity requiring a redundant well, so this, yeah.
Is the government requiring a redundant well, or is the government requiring a redundant well permit?
The well. So like DEQ would require that you get it into the law. Okay,
But to me, that's a given because it's in the DEQ's regulations. You know, and the DEQ doesn't, they don't write you a letter saying you have to have a redundant well, if you're gonna get approval for a public water system. You have to have, so I guess I don't see that even being necessary because it's written into the statute already.
they will have a permit from DEQ that will have it in it.
They didn't, no, you don't get the permit is where they give you after you've given them your whole design. And they approve your whole water system design. It shows you have 2 wells. So. I don't, guess, to me, we're asking for something that doesn't really exist. Because it's already written into DEQ statute. If I was to respond to that, I would just give you a copy of the statute, and say, here it is, you know.
But you said this could also apply to tribal community water systems, right?
Yeah.
And that would that fall under DEQ or
Right,
be?
it's have to go through DEQ to get a water system.
Our public water systems are run through housing. I don't know, but I don't think DEQ specifically is involved on trust property. I don't.
Yeah.
I'd have to,
Do they
I'd
have,
have to verify that.
do they issue redundant well notices though?
You meant that we were, I don't.
Yeah, so that's what I'm saying, I don't think you're asking for something that really doesn't exist.
I don't.
I think citing the statute and fine.
Public water system and safe drinking water act function, which is a federal equivalent.
Is run through
And
the.
it's delegated to the states, but not necessarily on reservations.
Right.
And I don't think the tribes here have it treated as a state status for safe drinking water.
They don't. It goes through the EPA.
Yeah, they have their own system.
So it wouldn't be DEQ, it'd be EPA. I
Yeah,
don't know if EPA has the same kind of in-depth regulations as DEQ.
you'd have to check with tribal housing, I guess, to see what,
No, housing or water quality program.
yeah.
They have the.
Water quality is clean water.
Yeah. It's SDWA, which is a separate part of the EPA, and water quality doesn't deal with anything with Safe Drinking Water Act. So
Yeah,
that's a whole different thing.
Just a letter from tribal housing saying that this needs a redundant well would be sufficient. For us. For this.
So when we go at it this way, why do you need that documentation?
So that, you know, that they actually need a redundant well. That they're not just drilling additional wells for no reason.
well, then that's just part of this DEQ statute as far as if you're building a new subdivision, it's a more than 5 lots, then you're gonna earn more than 15 connections. It just says you have to have a second well that's capable of providing the maximum flow or whatever. You know, they don't, there's no document they give you, it's just part of the statute. So,
Either we take it out or we change the language, and I'm working on changing the language, so required to provide the office of engineer with. Maybe the requirement is to provide something else.
Yeah, I would think that documenting, just copying the statute and giving that to us would be fine. Then we have our basis covered. We have to have a redundant well, because you have this statute. But, yeah.
That's different than what this says, though. So I would agree with them providing you with something that says what they're required to do, because this says documentation from the government anyway. So if you want the applicant to provide documentation that they are required, they can cite whatever requirement there is, and then we follow up on it, where the police are providing that. But this says documentation from the government entity, which may or may not exist.
Yeah,
Sure. What if we say, or citation?
Or
but yeah.
I can see why you would need that though. I get it.
you can have them go on record saying that they need it, you can follow up on it, verify it. If the government doesn't have document, if they don't provide something, we're not gonna get it. From the government.
Is that yes, there?
Or I guess I just don't see it's necessary,
Hmm.
but
I think it might be necessary if it's a tribal project.
and I don't know if the requirements are.
Well,
Well, we just get a surprisingly large number of people who just want to drill an extra well. And I mean,
yeah,
So is that what you're after here?
that's what I'm after here. Like, I am not trying to harass people who are required to have one. I'm trying to weed out the ones who aren't required to have one that are trying to get one. Is show me where you need this. And the problem is that it's a notice of completion. So it's not a preliminary approval like a new use. You know, same with substitute wells.
uh, basically. Yeah. Okay.
Keep talking, change, item 4, substitute well, the ordinance requires that substitute wells, you know, when you do one, you abandon the old well. Okay. Like seal it, fill it, grout it. And we wanna have this, clarification that it needs to be abandoned according to the administrative rules of Montana, which goes to like the well drilling construction standards for the state. The ordinance generally adopted all those. And here we just want to make an extra clarification that you have to abandon them according to those standards, which that also means that there will be an abandoned well log that's filed. And the substitute well abandoned well log requirement is set forth in 5. So that we can see that you have abandoned your old well. Because a lot of the old wells, when people are replacing them, they have perforated pipes and other imperfections that provide for possible source of the groundwater contamination. And then we still do have an out under 6. Because you'd be surprised. One of the things that we have a lot of arguments about with folks who need a new well is they don't want to abandon the well. A, it costs money, and B, everybody just wants to, just in case, have something, and so, try to give them some options where they could, make the case, to not abandon the old well, but we want to be able to force them to install sanitary well cap and mark the well location and do some other things that would, make it less likely that well would be a problem between the switch to the new substitute well and some future date where that old well might be put to use for a different type of use.
The administrative rules of Montana, 3621, 810. What do they require? Just, I don't know that.
Sure. Wells which have not been monitored for more than 3 years shall be deemed abandoned unless written permission is obtained from the board to maintain the well.
You're reading that's monitoring wells, not water supply wells.
Okay. You cite the wrong section.
Yeah, go to the Montana Board of Water Well Contractors. They don't find it.
3621, 10, is that the wrong? You got the wrong? Interesting, I note that the AI taking our notes, when you said that Montana Board of Water Well Contractors, that says the Montana, Florida Water Well Contractor.
I guess I should enunciate.
No, I just happened to catch that, I saw, just happened to catch it, I just.
Now it's water bill contractors. It's having some fun.
I have a hard time finding that right now.
So is the administrative rules, Montana 3621, is that correct?
No, that is we cited to the, monitoring wells.
Okay,
And it should have been, it looks like 3621, 670. I'm trying to verify that.
well,
Yes.
Another reason I'm asking is not only what does it require, but that sentence says should be abandoned according to. Should be, that means they have a choice.
It's 671. Abandonment, that's flowing artesian. Let's see.
670 permanent abandonment. Any well that is to be permanently abandoned shall be completely filled in such a manner that vertical movement of the water within the well bore, including vertical movement of water within the annular space surrounding the well casing is effectively and permanently prohibited.
Yeah, that's the one.
Okay, so it's a technical requirement, which is fine, so then back to the should, is that correct? should be abandoned according to that?
Well, they have to be abandoned.
Shall.
Okay.
So either way, maybe add that last sentence in there at the discretion of the OE. A letter from the well driller doing well abandonment. They're required to file a well abandonment report.
Not if they dug the well themselves and they're not a licensed well driller. And,
Well, if they're not a so they're not a licensed well driller, then they're not gonna hire a licensed well driller to abandon it. But. I mean, they could just go up there and pour bentonite on the hole themselves.
we can delete that.
I guess if you think there's. I think that's why the rules are there for water well contractors, that all that work has to be done by a licensed driller.
Yeah, and if you're, and I'm just, don't write anything yet, but it's just thinking out loud, if you're trying to give yourself a little wiggle room, yeah, a little wiggle room, maybe something like any deviation from this requirement. Maybe approved by the discretion of the office of engineer. That way, if something happening, they don't, don't write it yet. I'm just throwing it out. Do you want something like that, or do you need something like that?
Yeah. The deal is about the well logs is that they're not. There's a history of things not being done as well as they should have been. And sometimes the replacement well might have happened during that period from the mid-90s to now. And they want to move their water right into compliance. And, maybe back in 2001, when the well that got abandoned was abandoned, the person who did it didn't file a well log. I mean, I was trying to create a way where we don't trap ourselves because of, some legacy of not having, there's plenty of wells that are on this reservation. Like, they're everywhere.
So I'm throwing this out, any deviation to this documentation will be approved by, at the discretion of the applicant. Or that way, if it's something else that comes in, you get a chance to review it and decide, is it approvable or not. I don't, does that sound fair?
I think that sounds great.
At the discretion, At least if there is something unknown there, this is the text we'll say to them, or, you can review it and review the documentation and.
Great.
Works fine, if it doesn't.
I think that was, scroll up a little bit, good to see. One little grammatical thing, when on number 4. What if you substituted malfunction instead of misfunction?
So that.
Let's scroll down a little bit, sorry. Thank you.
Where I said any deviation in this documentation would be approved, expression of option in there, which was, I'm thinking maybe approved or denied. Doing good, guys?
Doing okay?
6.
I'm still reading.
Okay. Is 6 end with E?
Yes, sir.
So substitute well, non-abandonment of well being replaced, and then it goes on. We just say that they had to be.
If you could provide good cause for the old well to be retained, and maybe. You try to make it so we can create an exception. So if there's a good reason, like somebody's got a good well, but. You know, because of the property line transfer, they had to move one of the houses to a new well so that they didn't have a shared well arrangement, and then they were gonna use that well for a future development, and the well's perfectly good and functioning. I would allow them to put a sanitary cap on that well and until their aspirations of using that well came to fruition. That's just one of, there's probably an array of hypotheticals where you might wanna let somebody hang on. You know, sometimes, the old well may not be potable anymore, but they wanna use it for, irrigating their lawn. I'm okay with that, you know, but they want a new well that's, you know, deeper on a new permit to, I wouldn't really be a replacement well, but, you have another one that was in the same aquifer, but you know, doesn't have a pierced casing or some other kind of thing that's causing it to be contaminated, so it was a replacement well. I might let them keep, you know, keep that one other well for their irrigation. I'm just trying to think of ideas. But I would want to be able to, impose a couple of things in that circumstance. I'm not I probably can't figure out all of the reasons why somebody should keep a well in their place. Those are some of them.
That's fine, I just couldn't clarify, because I thought you said they had to. When you're saying, yes, me,
Yep, this is yes, but maybe clause. Also, I just like to use good cause. Let's get excited.
I'm more excited about the fact that some places you say well with a small W and other places you say capital W.
Yeah. It's so hard.
Oh, well. I don't know, but, you know, I don't like lists. Is it really necessary to list this like that? I mean, in your opinion.
I like having it so I can just say like, no, I can do this. Right here, it says it. I know you don't like this.
So what do you do when somebody just kind of goes rogue and digs their own well? You mentioned
The
that,
process for that is, you know, like you, on your own property, you can dig your own well. And there are a number of places on the reservation with shallow wells do exist. You even heard about one today. It's not a make-believe deal. People actually use water out of a lot of the shallow wells.
oh, I
The
know,
casing obligation is negated as long as your well is shallower than 10 feet. So you don't have, you know, the construction standards, state construction standards don't require casing. So there's, I mean, well is not well, is not well, you know, it's, yeah, so we just try to work with people and,
try to get them there.
do, you know, meet people where they're at and figure out what we're trying to do and try to have them get there.
Well, the reason I asked, I got a little distracted when I heard you say that before and I was looking something up. I don't know if you've ever seen that show, it's on the Discovery Channel, Homestead Rescue. Do you know this show? They featured a couple that's out in Camas. And they're getting, I think their last, I just looked it up, their last episode was earlier this year. But the show kind of celebrates digging your own well if you're gonna be doing this, so. Because we had the public comment earlier today. And the show is currently airing and it's showcasing people here on the res, a couple of white folks moved on, they got a place out in Camas. It's kind of celebrating that, so I was just curious, there could be. Even more of that happening, I don't know.
See, in general, is a lot of DIY. Well, water development on the Flathead Reservation. It's not all of it. It's pretty persistent throughout a lot of them,
Oh, sure.
you know, so.
Now, there used to be a lot of 30-foot wells here, right in Pablo Ronan area.
especially Pebble.
Especially Pebble.
That was there in shallow.
Yeah, I used to get a lot of calls on that, families getting sick. So. Anyway, sorry, I digressed. I just went down a rabbit trail.
So we will fix the W's,
Got a couple grammatical things on A. Installing a sanitary well. On A, submit. Should be well sealed, not cap. It's a separate word, well sealed. And then down on C, wellhead is one word.
that's why that wasn't kept.
It should, not a hyphen, but one word.
Yeah.
And we'll do that some
Yeah.
track change.
What do you guys think of this section?
The only, the thing that I'm looking at is must provide good cause, so. What is good cause?
You guys have used this before, so I frankly copied, what you've done before. And,
What do you think it'd be?
Good reason.
Red line in my red line, so.
Yes. Yeah, like-
Good cause.
So
Needed. Yeah, that of all things kind of really leaves it up to you to decide.
That's what I'm looking for on 6.
what if you put rationale instead of good cause?
You know, you writing? Written rationale,
That's the right written rationale.
written rationale.
I mean, it's not already implied with the first part saying applicants filing a substitute well notice of completion form. So I mean, they're already writing rationale on the form. It'd be a little redundant. I mean, it's a substitute well, but.
I think we should have a redundant.
We set you up for that. Add her up and
It's 4:30 people, I gotta keep you alive.
If form 634F asks for that, yeah. Form 634F require that rationale. We could apply for a not abandoning the well, not say why.
Form need to be readdressed. Given this.
Just say attached written rationale. It must provide written rationale. Then what we want to see.
Written, and then leave it now.
You'll probably need to put something similar to that on the bottom of the form too.
I don't want to invite people to do this, but
I mean, you have a yes or no question on here about if the old well was abandoned. And if it's no, because they wanna, not abandon it, then you have to put something on the form saying, provide rationale why you're not abandoning the old well.
all right, we will update it.
There you go. Okay. All right, we have thumbs up otherwise? Thumbs up. All right, so what I have so far is thumbs up on, all of them, but, 1067A, and that was 15. So 113.4 fines.
There's only one thing on fines. And I'm sure you guys will talk about fines very much.
Okay.
Thought we did talk about fines.
This is an update, not a new, it's not all new, it's just an update.
See, I appreciate that.
Four is the only thing, fines for failing to curtail illegal uses. If the water user is found to be using water illegally, you have to be notified by the water engineer or any staff who is so directed by the engineer to curtail the illegal use. The water user may be subject to fines.
So correct me if I'm wrong, doesn't the ordinance have the limit of what the fines can be?
Up to $1,000 per day for violation, and every new day of a violation is considered to be a
Is
separate.
that cited there or referenced?
Higher than this, I did, we did. Have, we did have some like not to exceed $1,000 per violation.
Oh, okay.
Each day is a separate violation, and I know. I had a fight to have that in there because it is redundant with the ordinance, but I thought it was important because it's in the plan section. So,
Agree with Ken, fine.
Well, why did you add this section here?
so that we know that we can find it. If we tell them not to. You know. They don't curtail the use. We just wanna set the expectation. At which point we'll all maybe have to figure out how we're supposed to phone somebody, which is an administrative thing that we haven't had to figure out yet, but we eventually will have to. Generally, though, I have tried to make it clear in here that whenever our office is looking to impose a fine for a particular thing, I'm trying to actually clarify here, because I think that you need to agree to this. Like that's something I just think that is, we need to have your direction via this policy, and it's just an additional clarification of the ordinance. But
Clarification on the ordinance or go beyond the ordinance?
I think this is clarification. And particularly clarification on how our offices role.
Yeah, not arguing with, for clarification, so if the ordinance already says it. How much of it you need for the procedures?
The ordinance is more vague about finding and where the origin and authority of the finding comes from. Read that section of the ordinance if you'll continue.
No.
Okay. Yes.
So I don't have a problem. I think it's probably not necessary, but I think it serves another function.
Yeah, I agree, I'm just trying to. All right,
Well, yeah, I mean, I think it's a notice between us, the OE and board, and it's also a notice the water users that, so I mean, both things, I think that's why I voted to have this.
are we fine with the fines?
Yep.
Thumbs up. All right, so with that. Is there another section update?
Nope.
Okay. Public comment. So if we're ready, we want to send on several of these to public comment. Out for public review. Correct?
Yes.
So, is there no public here, any public online?
No public online.
So offering public comment, there's no public to make comment, so, big board action if you are inclined to send out, all of the items listed except 21-106, 107, and 108, which we are holding for further review.
I'll make a motion to adopt water policy procedures except for WPB 2106, 107, and 108. We are holding.
Adopt them and send them for public review.
Exactly.
Okay, motion by Ken,
I'll second. Go ahead, George.
second by Georgia, all in favor, say aye.
Aye.
Okay. OE forms update.
Mr. Chairman, board members, the first, two forms I'll bring to your attention are, deadline extension requests. There is the old form in here. And then there is the new form that's in here, just in case you wanted to see them side by side. And, so the one that you're looking at today is the one that says it's not yet approved by the board. And, to give you the, the changes in here. There's a change in the important information box where it says, if an application is extended, the priority date, the old language said may be adjusted. The new language, as staff has informed me, they always adjust it, is converted to a will be adjusted. So that, if you're behind by a year, your priority date will be delayed by a year. Okay? The other changes that we had some formatting improvements.
So if you go.
Yeah.
Go back,
Sorry,
where was that?
so if you have,
The front box? Application extended priority date will be adjusted.
That should be two, but it's got highlighted and it's not highlighted.
Okay. All right.
all right, Mr. Chairman, so the next, item here, I'm gonna take you under, 4 of the new form, which has some additional highlighting. 4 was generally, restructured, a little bit because we now have multiple, deadline extensions, and so we have. We've always had this extend the approaching construction deadline for 6 months. We have now added extend the approaching construction deadline for 1 year. And that's $115 instead of $65 for 6 months. Additionally, we did the same thing for missed deadline. Extend the missed deadline for 6 months has always been there at $120. Now you can extend a missed deadline for 1 year, it'll cost you $200. All of these are at the discretion of the office, so none of this is like a guarantee, but we have had a lot of people who have had some struggles with some of the completion deadlines. And you remember, we did talk about this. You said maybe you should consider a 1 year option. This has both. And then, in addition to that, we did add, some language under the redundant well or substitute well notices of completion that failure to file those within a year of the missed deadline may result in, the revocation of the water. Because we want people to file those. So we have our records accurate. Those are the changes to this. We think that this will reduce our office's paper shuffle a little bit. For some folks, it'll give them a bigger grace period.
Bill 7F, any comments on those changes?
Yeah. All right, the next form that I have, sorry, Mr. Chairman. There, what you?
612.
Oh, yeah, sorry, Mr. Chairman, a little deaf over here sometimes. 612F is a brand new form, you've never seen this before, you've heard about it today, it's here right now in front of you, in your hands. It's a petition to declare an appropriation right or existing use abandoned. This has the same filing fee as a complaint, $55 formal complaint. A lot of the language was borrowed from the complaint form. We do think that it is significantly different enough to demand its own form, because it is a really different idea than a complaint. That's why we want to have this separate form.
Comment on three.
Of course.
There are people out there that really don't want to contact. And I'm wondering if you could soften that and since you contacted or attempted to contact.
We will, make that modification. Would you like us to go ahead and broadcast that into the complaint form as well? All right.
The city, where are you?
Oh, number three on form 612.
Yeah.
Paragraph 3.
What are you changing?
I'm just suggesting that instead of please identify the date, time you contacted the respondent, say date, time you contacted or attempted to contact.
I also had a edit on that.
Now, if that's gonna mean the delay of putting this form out, don't worry about it.
Oh, I think we can make this change and this isn't put out for public comment. If you tell us to change X, Y, and Z on this form, you can approve this form today. Sorry for not, giving a lead in on that. This is not like the W 15-day comment.
I got one little change up above and in the box under important bullet item number 2.
Yep.
Says all petitions are a matter of public record. And could say available for public review upon request. So scratch may be subject to.
I will make that adjustment.
Then I just have that small change under 3 in the parentheses, just delete FRWMB and Mrs. DOE who's doing the initial evaluation of this.
Says, need to get out of my problem, sir.
All right,
The next
I have 3 modifications so far. Anybody else have another modification?
So, this form in place, you have process and procedure to implement this? We don't have any of the policies or anything that we.
I would prefer to get those policies through their 15-day period before we start to receive.
Can we hand this out?
Yeah, I mean, it's only like 5 things that I wanted the clarification on, but I think it would be good to have those in hand, before we accept this. If somebody was to file on this form, we can always hold it in abeyance until the WPMPs, get their finalization.
Okay,
Okay,
any other comments?
No.
So I got one question. So like those, you had 2 individuals come in today. They both could not sign the same form because they are different petitioners. Is that correct?
that's my conclusion.
They could be put into like the same proceeding before the engineer, but they would have to file 2 separate forms. Yeah.
You ready for acting?
Yes.
So, any public comment? No public online, no public in the audience for public comment, so moving on. Board action to approve 607. Please,
I'll make a motion to approve form 607F for the modifications, revisions.
motion by Roger,
Second.
second by Ken, all in favor, say aye.
Aye.
Right? Same for form 612.
Make the motion, Mr. Chairman, to approve form 612F.
Motion by George,
I'll second.
second by George, all in favor, say aye.
Right.
Aye.
Office building project planning updates, do we have any?
We can start off and say we met with the architects Monday before last. Okay, last Monday, very productive hour. They seemed very, very eager and willing to work with us. Very receptive to our thoughts, concerns. The one thing that did come up is, what level do we need to get approval from the board for what they're doing? My response was, well, anything that has to do with anything financial, we have to come by the board. They said, but on the rest of it, and maybe we the Supreme Court suggestion, is a major decision or is it something else? Without defining what a major decision is. And that's the only thing I can think of, because there are gonna be things that we make this red or green, that's probably nobody cares. But do we have 2 rooms or 3 rooms? That's something maybe somebody cares. So I think what suggesting is that some discretion be given or authorized with the committee to make not non-major decisions, but kind of run the mill type stuff that we have to do just to keep the process going. Leave it to the committee to figure out when there's a possibility of making a decision. There's be a lot of tiny little things that have to be done.
Yeah. I'd say probably, especially the smaller items, we keep things going, would be good, but somehow find a way to track them and report so that everybody knows. Who else? What else?
Well, I thought Ethan made a really good suggestion during the meeting. And he suggested that the team meet at is it the Missoula?
Missoula Regional Office for the Montana DNRC, and water rights. On that front, the discussion is they wanted to come see our facility and find out what's not working. I really kind of cogitated because, Georgia made, well, that's a long list, or maybe a short list of things that are working, and I thought about that, and I thought that was astute, I thought, well, hey, why don't we look at a water right office that does work? And so I was able to get that scheduled for Monday, 7/28. Monday morning in Missoula, scheduled with Payla's outfit and Jim Nave, and I'm here now offering if you would like to, any board member would like to attend that, that's fine, but we wanted to show the designers something that does work. That's a great water rights office. I haven't worked in a couple. I told them it wasn't supposed to be limiting their design or anything, but to just see something that is got a lot of the function that we would need. It doesn't have as good of a board meeting room as I think you're going to ultimately need. It's a little small on public meeting space. They usually do that next door, but in terms of the office structure and things like that, it totally works. The receiving and that kind of thing, so.
And so with that being procedurally where we at, what?
One thing.
Yeah.
One thing we did address was paying them for their services, and we asked them to come up with an estimate.
Yes.
For, estimate for preparing the estimate. Estimate for preparing the plans.
Yeah.
Kind of a preliminary
Yeah.
estimate, they agreed to that.
Okay.
They provided, in your packet, they sent across some pretty detailed information on how they'll proceed. And it looks like this initial phase is an hourly rate. They just bill for the hourly rate. They don't have a large, contract fee or consulting fee, which I thought that was very fair. And I guess what impressed me, and this is beyond any discussion of just, designing a building, but I wasn't aware that they have like a 10% commitment of giving back to the community. So if you go on their website, they're actively involved in nonprofit work. They give back. And that meant a lot to me personally. So they're community minded.
So we. I don't know how clear what I sent through, was, about health.
Yes. I wrote down your questions and Ken and I were careful to ask both of those questions that you raised. So, and they seemed very cognizant of, working with the board and how you go about going through the steps when you don't know yet if you're gonna have the funding, right? So they were comfortable with that and they understood. And I think the other thing we communicated to them, and you guys weigh in if I'm misspeaking. But I think we made an effort to communicate. We wanted to get some idea of cost before the end of this fiscal year, so that when we submit the next budget to the state and the tribes, we have some numbers to send them. And so if you look at their, kind of their roadmap, they've indicated the number of weeks they think it will take to come up with that. And they really based that timeline on our fiscal year. So they're very much aware of what our deadlines are. Am I representing this?
Yeah,
Is
yeah.
that okay?
Perfectly.
But I thought, it was a good point you raised, and they're taking on with that. So.
And at some point, in the near future, we'll have some sense of what the first amount of money is going to be. And so we know whether or not we have it in the budget, or if we have to ask for it. Yes.
At least we asked for them to do it and they agreed.
Yeah. Cool.
What we do have this draft contract and it has got dollar amounts in it for their design fee. So they had, figured they could complete all the work described in here for $14,100 plus reimbursables. And then they're gonna, the 10% design brings it to a fee cap after the donation of $12,690. Which is architecture, Loki architecture plus design. And then they'll track their time spent on the project and will forward invoices monthly.
What did you want?
Exhibit A, scope of services.
Second to last page.
Sorry, second to last page.
Something that came out in the conversation too, that was kind of interesting, is when we were talking about potential sites. They felt that sites in R Lee would be a lot cheaper to develop than, for instance, Vernon, due to, soils analysis. That there was, how did you describe that, that there was an issue with soils in Vernon that could make building costs.
Radon? I can't remember.
That is geostability.
Geostability, thank you, yeah.
Hmm.
And then the other part of that that would make it cheaper for our lead was utilities. It was cheaper to connect to utilities and then that geostability, so
I think that depends upon where you're at in Roman, but.
it could,
They threw that caveat out for
yeah.
sure.
No, yeah, I mean, there's a lot of wetland soils around here, so, but I mean, to me, we don't have to. Think we should be looking anywhere, not just.
Yeah.
Going on or.
Well, we can look, but it opens the way, I think you can. Not dependent on us.
Yeah,
If you look at this site, we felt it had to be on the reservation.
Yeah, well,
Yeah,
that's
yeah,
gonna be, there, yeah.
but I'm not discounting Folsom or Pablo or anywhere else.
So hot springs.
What?
What?
Yeah, that's hot springs, you know, stick our bodies out there.
So the initial outlay, cash outlay. So you said, so I'm looking down here, it's at 14.1. And it says our cap fee after donation will be 12.6. And then they say plus reimbursable, and they estimate 730 for reimbursable, so is it 14.1 or 12.6?
It's 14.1 before the 10% in-kind donation, which drags it down to 12,690, and then there's a added back in reimbursable expenses that are estimated to be 730.
How does it work?
So that's 13,420.
Well, so what do we need to pay? 14.1 plus 730?
No, 1260 plus 730.
But,
690.
well, I mean, that's what their cap would be, like not to exceed that amount. But their invoices would come monthly, so it could be $500 in a month, it could be, $5,000 in the next month.
Okay.
So I think like board compensation, you'd have to approve it at the meeting and saying like, okay, here's the invoice from Loci for $2,000 something, board approval on this invoice.
For them to start spending money, my whole point is, what do we have, and if we don't have it, we need to ask for it, and I don't know if we're gonna get it right away, so. How are we gonna finally proceed with this?
Well, we built in about $25,000 into our budget for doing this,
Okay.
so that's already built into the budget, so. And we can always do a budget amendment too, so,
Okay.
so I think we're covered there, but. So you made a good point that typically in board meetings, once you start paying bills too, that's one of the first items in the agenda is approval of financials, so. So that should be something to start thinking about.
So. Are they working now? Or we have to approve the contract? Or? They're not working yet. Are they? I mean, this is the total contract, we have to approve the contract?
Yeah, I think we would have to approve before they could start anything, so. And we told them that we would be discussing this at the next meeting.
Yeah, this is a proposal.
No. Exactly, so have you looked at all this?
Yeah, I mean, I have some changes or edits, I guess, that they would need to be aware of. I mean, they're very minor. Couple of them would just be to spell out the entire name of the board, in the contract. They shorthand it a couple times. So keeping it Flathead Reservation Water Management Board is, important, and especially if that's where funding's coming from. And then just a couple other spelling issues throughout here. I also didn't know what reimbursable expenses was, like, what? That's not defined anywhere or categorized anywhere in here, so I don't know what that is.
Is that like their travel time and meals and things?
That's what, I don't know. It's not in the contract, so I don't know.
Should we get those comments all back to them so they can respond?
Yeah, I'm happy to type it out and get a document and provide it to the group to give back to them.
Ethan? Where you at with this?
I look pretty good. I mean, I agree with, Haley's, minor changes, but. I mean, and then I just want us to keep track of like, there might be some add-ons, like if we wanted to have. Additional design photos or videos, those would be an add-on to this. But, I mean, I'm not crazy about this particular contract format, even though it seems like it must be a standard thing.
I've never seen anything like this. to be honest.
So I feel like, that part doesn't give me a whole lot of enthusiasm, but I gather that it's something that they routinely use and they have decided that it's part of the standard form of architect services. So maybe Roger's seen something like this before, but.
I think this is a pretty standard architectural services contract. So,
Well, given that, really, I know we have it, not everyone's had a really chance, and you're gonna make some comments. So we're not gonna approve this today until we get the response on that.
it's not a contract either, because there's no signature pages, right?
Yeah, this is the council.
So I
Right,
think it's. Yeah, I think that's basically it. It's a scope of it.
Yeah, I think if they're putting in anything about like percentages though, for like additional services. I mean, if that's somehow gonna like tie you guys to. If you were to request additional photos and then they tack on the charge for that and 15% like it says in here. I think just being aware of, what does additional services mean? So I don't wanna get you guys in hot water where they should give you a bill for like 15% additional charge or something. You're like, whoa.
Well, we'll make it comments.
Mhm.
I mean, everybody chance to take a closer look at what's in hand here. If this is not a contract, this says board action. If we approve this, it says contract. Is it a contract then?
No, this would just be approving the scope of services. Yeah.
Okay, we'd have to clarify that, on record, because this says approve a contract. If we do that. Now, because we're approving it, there's also financials in here. Right? And the money we just talked about. But when we prove it and they start working and we start racking up. the bill, right?
Yes. That's what I understand. And that, that once we go back to them, this is draft. Obviously, I would imagine that the next version comes with our changes and a signature block. That's what I'm thinking.
Okay, and then. So even what you had just talked about though. Is there something in here? Or should we have something that is, if they're looking at needing I'm not sure if they're calling it just additional expenses. Or
Add-ons.
add-ons, yeah. But they get them approved ahead of time, or do we just assume that they use add-on?
That's what I was curious about, is if it comes from like them just doing it, or does it have to be at the request of the board?
Or at least a committee, and if the committee decides it needs to go to the board, then it goes to the board, but. I'm personally more comfortable with add-on being requested, you know, if they have to request them, maybe even in writing. Does that make sense?
Sure does.
Well, at least to the committee, and then if the committee thinks it needs to go to the board, then it comes back to the board, that way it's. Might take some time, but
Add-ons are more money and it's public money,
It's
so.
just- it's just add-ons. The rest, I think that we've got a fair idea of what we're talking about honestly, I'm still not sure. Are we talking, we're paying 14,100 or we're paying 12,690? What is it?
I am sure about that.
What is this?
The 12,690s.
Yeah, what's this donate 10% or fee to help support the project?
They donate some of their time to their projects.
Doesn't say that, it says fee.
But we'll get additional clarification for you from, so I have, that we need to track down a better list of what the additional services are, a process for requesting additional services are, clarification about the donation language. And then the seven. Sorry, the reimbursables. A list of example reimbursables, right?
Yeah, so those comments are gonna come from me in the document, and then you can just send them the
And
document.
then is some of this might be, maybe it's already there. Additional services beyond those described above may be performed at the owner's written request. So they're talking about additional services that we request.
Right.
And I'm concerned about it is any additional, any add-ons that they might think need to have. And then clarification on reimbursable expenses. Says they estimate 730 for phase one, and if it doesn't go beyond that, I think we're fine, but if it goes beyond that, we would need to get that clarified. Any other comments?
No.
Questions?
So,
Yeah,
if you. Ethan, were you gonna have these people come to your meeting and in Missoula field office?
Have the architects?
Yeah.
Yeah, that's the whole point of the Missoula trip is to show them the Missoula field office.
So our next meeting was until the 31st, so that we won't have an approved contract by the time you have that meeting down in Missoula.
That's an issue, yes.
That's where I was going with that.
And also,
So your question is whether or not they'll agree to go to the meeting?
Yeah, I guess, if we're okay with just telling them or we've got amendments to their contract, other than. If they want to attend the meeting,
Just invite them at their own expense, if we don't have a contract.
yeah. Yeah, I guess that's all we can do. We can't commit money if we don't have a contract.
Yeah, and if they can't, then we have to hold off that meeting until after the contract.
okay,
And then I'm changing, like I'm writing here, it says scope of work, so we're not approving a contract, we're approving a post contract or scope of work, what is it called?
Scope of work.
Scope of work,
Proposal for architecture.
Approved today, Is that what you're asking? To approve today?
Yeah, because our agenda says contract, but if this is not a contract, what are we following?
Yeah, I don't think there should be any board action today.
Okay. All right, that's even easier. Any other comments, questions, concerns? So you'll have time to take a look at this, so look some more, if you have any more comments, give them to Ethan and to Haley.
I'll get everything to Ethan too, so you can send it out to him.
Oh, I was just gonna say it's about 20, I think we're going soon, but we
Yeah,
could skip. We could skip 6 and just go to 7 and take care of that, wrap up, I guess is what I suggested.
proposal is this,
7 will take 5 minutes. And if we skip 6, I might be able to add in the section we deleted out of the agenda for the next meeting.
We do have that little section that went out though, that could be quickly approved or
Is it on the agenda?
it is, yeah, 6.3.
Well, I'd like to keep all that as a package for now. Since it's all WPMP.
all right, state what you're proposing.
Okay, so I'm saying skip 6, jump to 7 and.
All right, proposal is to skip 6, jump to 7, and then, we complete the business for the day. Good, all right, ready for that. All right, move on to item number 7. Oh, I see what that is. And I think I looked at mine,
Yeah, that's fine.
okay, so any committee compensation, any public to comment? The public online?
No public online.
That's online, and public in the audience, so 7.1.3, approve the board committee compensation. Taking action.
Chairman, I move to approve board compensation for June 20.
Committee compensation, really,
Committee compensation for June 2025.
motion by Ken,
Second.
second by Georgia. All in favor, say aye. Aye. On the 7.2 board compensation for June. And on the record, no public to make comment, so there's no public comment, any further discussion on it? Everybody good? Ready to take a motion to approve, you ready?
I'll make a motion to approve the board compensation for June 2025.
Motion by record,
One second.
second by George. All in favor, say aye. Approved. All right, yes, it is approaching 5:30, and we're scheduled to go to 5, given that, next meetings are scheduled for arguments July 29, board meeting July 31st. Board meeting August 7, or 27, so those are listed for now, so. George, anything else?
Nothing for me?
Ken?
Nope.
Good. Ethan? Anything else?
Nope.
Really?
Nope.
We're good. Motion to adjourn. Motion by Ken, second by Roger, all in favor, say aye.
Thank you.